Sir, I will kindly pardon what you mentioned, Lords. Matter is not your Lordship's vote today. The Lordship has adjourned this matter today, 2J battle, my Lords.
Yes.
In part heard, my Lords. That's all. We have completed argument, my Lord. So also state has substantially finished their argument. Hardly it may take 10-15 minutes. I pray for me because they will argument today, therefore probably it will come. So let it Monday, my Lords, at 12 o'clock.
Your Lordship, on Monday, 18th, that your Lordship might have remembered that I will and FS matter. Your Lordship has already.
After that matter, can you
Both the matters have to argue because this matter, this 2J matter, your Lordship has
done? Oh, Tuesday. Tuesday.
on 25th, your Lordship has.
So matters are already fixed. Your Lordship. No, let us try. Mr. Minister, come prepared a little bit.
18 plus of 18 is to be disposed of. That matter, your Lordship, limited grievance, your Lordship has fixed that matter, and they have taken time to finish their argument on that day.
Okay.
So in that case, and this.
After that, yes, we are not giving a very categorically that will be taken, we will make an endeavor.
Okay.
Let the page mention be over.
Page 1, item 1 to 3. Page 2, item 4 to 8.
Can it be on 21st?
Is it
Scattered matter. Scattered matter.
better go to particular page?
That's page 2, item 8, my Lords. That's yesterday, your Lordship had adjourned matter, it couldn't come and we have made a mention along with Mr. Mishram, your Lordship have kept it today. That's I pray only was 12 AM. Because it's short matter, we can finish within 20-30 minutes.
All right,
12 then, my Lord. Be obliged.
inform the council, all of the council involved in these matters.
Yes, sir. Only Central Provident Fund Commissioner sole responded,
All right.
and only 2 councils were representing all the petitioners, myself and Mr. Mishra.
Okay, just Mr. Mishra is not here, that is.
So, his associate is here.
Okay.
My Lord.
Page 5, item 9. Page 16, item 10.
Item 10, my lord.
This is covered by your Lordship judgment. This is appointment under rehabilitation assistant scheme, my lord.
Yes.
Your Lordship has delivered a judgment last week. This is covered judgment, my lord.
No, all matters are not here. Some 80% matters are covered, but my lord is party to some of the
Some
orders.
of the matters. Will be taken up by some of the things.
So,
My
your lordship-
your Lordship order. Oh, my lord, take it.
Monday,
I am submitting for Monday.
Monday, my lord. 18th, my
He
lord.
is also the same subject.
My lord, sir, I have no objection.
My lord, one of the matter.
Fix it to Monday at 2 PM so that Monday at 2 PM.
One of the matters are left.
Just give the list.
My lord, in that matter, item 10, only one prayer is there. The lordship, that first matter is not similar to my lord's judgment. That may be dealing, that your lordship
That on that day you point out.
yes, my lord.
Because without hearing the council for the petitioner,
My lord, I am the petitioner in that case.
you are
My
petitioner.
lord, I have-
Respondent is also there.
my lord, so that is Ritanjali Giri case that,
You bring it to the notice of the court that day.
my lord.
Interim orders to continue. Interim orders to continue.
Interim order is not there.
Where it is there, it will continue. Well, just check about the interim order.
Page 47, item 11 to 13.
Lordship, item 12, that matter may kindly be taken up today. Lordship, I had mentioned it earlier also.
Keep it there.
Lordship, before rising on this page, that.
We are here to take up matters.
Lordship,
To have patience, wait till your term comes.
Lordship. Item 13 may be taken up today.
Page 48, item 14 and 15. Page mention over.
Pardon, my lord. Lordship, my lord, matter of my lord, this case is piece of that today on 12 PM, my lord. But my case not listed, the bench My lord, kindly taken on Monday, my lord.
It is part of matter.
Yes, my lord, Monday, my lord.
This appropriate bench.
Monday, my lord.
Just take out the.
Yes.
Then should be, it's the matter. Not Monday, any other day.
I mean, pardon, my lord. Fresh readable filed by the state. A contempt petition has been filed, your lordship may fix to any day next week.
My lord, similar there, two read appeals placed. Next week.
Pardon to mention, all these cases were your lordship directed to list it today, my lord, but it is not listed. My lord, the urgency is in the meantime. My lord, execution case has been filed before the relisted regulatory authority, for which your lordship directed to list it today, my lord, but it is not listed, my lord.
Today it cannot be, you just list it.
My lord, on 25th, my lord.
My lord had directed to list it on 31st August. That Professor Matter of Burla Medical College, my lord had asked government to take instruction, and it was listed on 31st of August. It could not reach. And that's an urgent matter, my lord. Maybe I've already filed a counter. It can be disposed of within 1 minute, my lord.
Already.
This means since 26.
Lot of holidays now in this month.
2023 also.
For us. It will be listed.
It's a case of regulation. It's a case of regulation. It's the state of file rate appeal. It's a case of regulation. Similar order passed in respect of
Regulation.
regulation minutes. The similar order passed in respect of other employees has been confirmed under Supreme Court.
Regularization.
Regulation minutes. Means the petitioner have completed more than 25 years. Yes, minutes. And yes, minutes. Yes, minutes. Currently, Lordship has also directed them to refer the judgment minute and directed the state to take instruction minute. But the matter will Lordship fixed on
Urgency, it will be taken up before the regular bench.
minutes since
Why urgency? Regularization matter, it will be taken up.
this matter has been filed since 26.
It will be such 2024 October.
They're challenging the order of suspension, Your Lordship. We're challenging the order of suspension. This matter has been filed since 26/6/2023, but not yet been listed, Your Lordship. So read appeal, Your Lordship.
26 June.
Yes, Your Lordship.
Have you checked up whether there is any objection?
Lordship.
Whether there is any objection? Has to
No objection, Your Lordship. All defects have been cleared.
take up this matter.
I may be pardon, my lord, one matter.
So what? Yes.
My lord, one WPC 23314, you specifically directed the matter to be listed today, but the matter has not listed. It is matter regarding that construction over the Gochar land.
All right, to come in the next week.
My lord, I have memo. I'm handing over the hard copy of the memo to the court master.
All right.
One phase recouple. Documents are going to proceed with the resolutions by 8 people, let's say. It's the role. I have filed it to the honorable single judge. The honorable single judge, while admitting the matter, is notice the opposite parties. So for staying is concerned, Malad, it has been denied and the notice is issued. If it is published once, Malad, I have to make minimum 150% of the participant application again. And completely against the rules, Malad. They are going to issue in the case.
Okay, it will be taken up on 18th priority matter.
To mention what item number 9, last matter, WPC 2387721. We have filed an application for amendment, and that is filed since 22/6/2023, which has not been listed. Let it be brought from the registry. That is IA number 9168 of 23.
It is on the list today. Maybe just check out, maybe in the list is not being reflected in the cost. He'll check up the matter. Number of cases we have restricted. Because of this rationing method, some cases are going out of list.
Sir.
Just check.
1 minute.
Council it can't be completed in 1 minute.
Pardon my lord. See, the 9/2022, but the matter is not being listed. The proceed matter.
All right. It will be listed on the next week.
Monday.
Monday is a lot of matters are there. Monday may not be possible. Let us see.
Fix 2 lots.
He'll be fixing the date. He'll check up the diary and then fix the date.
Lots against the order of single judge that it is a motor vehicle accident case. Husband of the petitioner died in the year 1991, but it is pending still. So they are not getting the financial benefit. So the case of death.
Delete appeal.
My lord,
How the motor accident, the accident matter can be subject matter of a writ petition.
For several days, I am mentioning.
Check over here.
Pleadings are complete.
Lordship, a similar matter is being taken up tomorrow. I'm just requesting this matter should be attached with the same matter. It's regarding the association to association, and the election is on 24. If it's get delayed, it's will be infructuous.
File the special, another appeal.
Yes, sir.
New appeal.
Yes, sir. It should be taken up with the same.
Transition matter is tomorrow.
Lordship.
A conversation. Supplementary list, stress admission item number 1. May I please, Your Lordship, at a glance, the order dated.
On last occasion, your lordship had directed to take instruction. They have published that instruction, but that is not sufficient. If
Yes.
I don't know.
we have published that instruction, so that is not sufficient. Lordship may see that instruction. Your lordship may grant me some more time so that I can take that concrete why they have paid that amount. Just he has shifted his responsibility of the reason behind it. He has not.
But don't you find it is a very abnormal?
Yes, Mala, that for that reason I am saying that the instruction is insufficient.
Some other day to fix it.
So in the meantime, the DO also has submitted another report. I will collect and file it. Lordship call on 21st.
No, 20.
And I have talked with that DO, so they are admitting that is irregular.
22nd. 22nd. Few matter. 22nd.
And your lordship may direct me to file an affidavit to that extent because
We will not direct. I will just observe that you may file the affidavit.
yes, so that I can file by up an affidavit.
At the request of Mr. M.K. Kuntial and additional government advocate that the matter will be listed on 22nd September 2023. Mr. Kuntial has submitted that in terms of an order dated 5th September 2023, even though he has received the instructions from the authority, but the instruction is not adequate. So by the next day, the comprehensive instruction shall be obtained. However, the opposite parties may file the affidavit, the reply affidavit. In the meanwhile, Mr. Niranjan Linkal and the council appeals for the petitioner. 22nd, it will come again. Yes.
Item 2.
item 2 is a public interest litigation.
Yes, sir.
Students in Gajapati district from class 1 to class 8 are not provided with books in their mother tongue. 50% of the population of Gajapati district have
It's a matter of state policy. I thought yesterday when the matter was mentioned that the state government publishes this Telugu, the books, but for later on I understood that it is not published. You want the publication of the primers in
they ought to be brought from Andhra Pradesh, the books, textbooks. Previously, they were bringing, they assured. From 2015, these people are struggling, bringing the notice of the state government. And they are assuring,
I'll take
but
instruction.
they are not providing.
come again on 22nd because it's
Some more
fundamentally the matter is linked to the policy of the government.
On 25th, your lordship call is not 25th.
25th.
Smell.
All right. The request of Mr. M.K. Kuntial and the additional government approval that the matter be listed 25th of September 2023. Meanwhile, regarding availability of the textbook in Telugu, which is the subject matter of the petition, the instruction be taken from the competent authority. The grievance is two sort. I'm just spelling out. First, non-availability, and whether the state government is publishing these books or not. That is an issue. If the state government doesn't publish, their request is to bring it from the Andhra Pradesh.
Besides this, Telugu teachers ought to be, bilingual teachers ought to be provided in the classes.
So no, that is the entire thing I'm telling you. It is falls under a state policy. We cannot do.
So far as
They have interest in learning of the mother tongue. This already we recognize that. But ultimately to provide the infrastructure, including the textbook, are on the policy matters of the state government.
So far as appointment of Telugu teachers, we have also issued a fresh advertisement for appointment of 370 Telugu teachers in the meantime.
Yes.
Item number 3.
I may pardon my lord, then item 1, your lordship, fixed it to 22nd. If may I pray on 21st, because I will not be on 22nd. It may
And here also,
21st.
both make on 21st, huh? The earlier also 22nd. This is 21st, okay.
Item, pardon my, item 2. But whether date, it will be taken up on 21st.
No, item 2 has to 25th, item 1 has to 21st.
Okay, item 1. Already item 1 only.
Item number 3.
Item 3, my lord. There is an I for condonation of delay.
It is there, my lord,
Only 28 days delay. If my learned friend has no objection for delay.
That was no objection on the first day. That is why my lord have heard it on merit. And merit, my lord, I will only place 2 to 3 lines.
Has delay to be condoned?
That is there, that I know, man. Can be taken up today also. I have no objection to the delay.
Okay, how many days delay?
20 days.
20 days.
In I, Mr. MPL and translating to the appellant applicant is an application for condoning the delay of 28 days.
Yes, madam, because that COVID period is to be excluded. If it will be excluded, how will
28 days delay, but there is no SR. SR has not been done even. It is there. There is a delay of 9 days.
9 days.
In filing the intercourt appeal from the order dated 17th August 2021 is passed by the London Single Judge in WPC, OSC number 1629 of 2015. Since Mr. Das, Somich Mardas, Current Counsel, appears in whip's notice for the opposite party. No formal notice is issued by this court. Mr. Das will be outside the submitted that the opposite party will have no objection if the delay is condoned. We have perused the causes assigned and also taken notice of the concession given by Mr. Das and counsel to the opposite party. Delay stands condoned. The result of this application is allowed in this portal. Yes, now come on the main appeal.
I need an explain, my lord. One minute.
Ajit who? My lord, only one point, my lord. Can you see, my lord?
On 21st, my lord.
That is small. A poor person is suffering. That is why anxiety. Otherwise, nothing.
Is this matter?
21st.
21st.
Yeah, 12.
Yes, ma'am. Yes.
Yes, ma'am.
There shall be an endeavor.
It will come as
finally.
It will come as first case or second case.
Yes.
Before 12 it can reach.
It will be disposed of at the stage of
Whatever we decide, the person should not be just put on tenterhook. Let him know that what is happening in the court.
Much of it.
But so far as the connecting matter is concerned, my lord, I had filed this with your polling. There is only 20 days delay, my lord.
What is the connecting matter?
The connected matter, that same, the issue is same, my lord.
WPC 27295.
So document number is 1477.
147?
More the matters issue is same. In one case, Honorable Single Judge had directed to consider his case, even if that in his case, Honorable Judge has dismissed.
But in the second matter, there is also delay. Do you have any objection? Do you have any objection?
I have
He has filed.
Okay.
No objection.
Since matters are similar, delay can be condoned and both can be.
I have no objection if it means condoned.
But Mr. Abhishek Mohanty,
No, my lord, SK Mission, Supreme Mission.
SK Mishra Council appearing for the appellant applicant. There is a petition for the continuing the delay of 25 days in preparing the interpretation against the order dated 13th September 2022, passed in WPC number 27295 of 2021 by the single judge. Stop. Mr. M.K. Kuntiel and additional government appears for the opposite parties and submits that the opposite parties do not have any opposition if the delay is condoned. Having perused the causes assigned and taking note of the above concession, we condone the said delay and the result of this application is agreed and disposed of. The appeal is the matter on 21st along with the earlier repeat appeal. Okay.
Item number 4.
Excuse me, my lord. In this case, my power may be deleted, my lord. Abhishek Mohanty name reflects in this case, my lord. In the sub-item.
I was just searching for you anyway. You have retired from the case.
I've joined the panel, my lord. That's why my power may be deleted.
Be there. Sometime he will not be available. I will ask you to appear before this matter.
He can't appear as joint depend.
Item 4.
Item.
The petitioner filed the above CMPLA for restoration of the OGC, which was dismissed for default on 14th March 2022.
Why it should be restored?
My lord.
Why it should be restored?
My lord, at the time of the filing of the OGC, the petitioner engaged different lawyers. One, Mr. Brajakumar Dogara, lastly engaged. He was died in the pendency of the OGC.
Who is the petitioner?
Advocate who was appearing for the petitioner.
What is the name of that advocate? Who is the name of the advocate?
Mr. BK Dogara.
B.S. Dagara.
BK Dogara.
Sir, BK Dogara. Brajakumar Dogara.
Brajakumar Dagara.
Hey, Brother Kishore. I'm sorry. Brother Kishore.
Brother Kishore Dogara.
BK Dogara.
Yes. Brother Kishore Dogara.
The objection in such circumstances normally
Should not be because actually Mr. Dogara died during that period.
You are Mr. Samal.
Biswati Lenka.
Or Mr. B. Lanka say. Is there any the interim applications for delay or anything?
Yes. 8 months.
Have you filed any IA for conviction?
190.
190, it is there. Flat B.
I think you will not oppose it.
No.
Yes, Mr. Mohanty.
Email.
You have any objection to this?
No. That I have already. There is a limitation, but 8 months limitation.
But Mr. This is an application 190 on a section 5 of the Limitation Act for continuing the delay of $47 days in filing the petition for restoring the OGC number 14181 of 1997, which was dismissed for non-prosecution by the order dated 14/3/2022. Stop. Mr. D.K. Mohantil, an additional government advocate. There is a private respondent.
Yes, notice.
Notice has to go. Just issue notice as to why the aforementioned delay shall not be conducted or any other order or order shall be passed in the circumstances of reference. Notice is made returnable on 19th October 2023. Since Mr. D.K. Mohantil, an additional government advocate, appears in with notice for the opposite parties number 2, 3, and 4. 2, 3, 4, 2, 6, 6. No formal notice in respect of those respondents. Opposite parties is called for. However, the appellant applicant shall take steps for service of notice on opposite party number 1, 1A, and 7, the registered post with AD within 3 working days from next.
Item 5.
Published.
May I please access? Yes. It is a very simple matter, my application under regulation 2, which is issued notice issued and retrieval order was granted in my favor. This case was listed on the date 19/8/2022, on which date I informed the Honorable Court, based on the instruction from the trial court lawyer, that the deceased sole deceased writ petitioner has died. Without giving opportunity to me,
I am for respondent 1 and 2, my lord. Let's say grant 2 weeks time to file objection, my lord. The miscase.
Always. Because in such matter, usually mistake even if committed by the court, that should
The honorable single judge should have asked them to substitute the.
that is what I don't. Time was not granted. We do not see or know what at all this matter was brought to the learned single judge or not.
No, that is there in the impugned order. It is reported by Mr. Misral on counsel for the petitioner that the sole petitioner has died in the meantime. It is in the impugned order itself. That is why I am saying.
Yes, what possible objection can happen? When it
can be remanded only. No advance.
Against dead person. This I did not recollect.
Actually, I don't have any. Actually, I don't have any documents. I have not gone through the documents.
No, that
you will get opportunity to argue the matter on merits. But now it is
I am not.
Remanding. I will give.
Always.
Can I try one thing, my lord? Let's say convent delay, fix some other date, my lord. I take instruction from my client. I have no documents at all, man.
No. Is it material instruction? Or instruction?
I think you client will not say anything because absolutely on the face of order, this order should not have been passed.
And the litigation is not going to end.
Sole petitioner
continue from
without checking up whether the cause survives or not. No order can be passed. Final order. It is as simple, but if you tell your client that matter, if they have opportunity before the learned civil judge. Right, I don't think any sensible person will tell anything to you.
Then let's see.
Order 22, rule 11 or 12. The counsel who was appearing, he continues.
Yes.
Well, there is a provision in CPC, the procedural part. One bench should have taken note of his contention.
First take on in IA 3809 of 2023. And Mr. Such. This is an application for condoning the delay and filing the writ appeal. Intercourt appeal from the order dated
25/1/23.
25th January 2023, passed in WPC number 457 of 2013 by the learned single judge. You are Mr. Naik, P.K. Naik, Mr. P.K. Naik, Planet. counsel appears for the opposite parties number 1, 2, 1, 2, 3. You are also for 4 and 5, Nirmal Sahu and other?
No, my lord. I am for 1 and 2, my lord. Sundarya Maji and Prasant Prananath Maji, my lord.
All right, appears for opposite party number 1 and 2. And Mr. D.K. Mohanty, learned additional government advocate, appears for opposite parties number 8, 9, and 10. And waive notice. Issue notice on the opposite party number 4, 5, and 6. Or 3, 4, 5, and 6. As to why the aforementioned delay shall not be condoned or any other order or order shall be passed. As deemed fit in the circumstances of the case. Notice is made returnable on 19th October 2023. The applicant shall take steps for service of notice on those opposite parties by registered post within 3 working days from today. We have to issue notice on them because if it doesn't represent 3, no, at the back, no order can be passed. It's not fair. You wait for some time, you know what will be the result of the case.
Yes.
You are represented in the writ petition?
Well, I have no, he has not appeared. On that date, I was put noting that I have to take first notice upon the opposite parties.
No, were they represented? All those opposite
No,
parties?
no. Notice was not sufficient.
Or notice was
Notice on that day, I was to take first steps. And inform the Honorable Court that the sole petition has died. So some time may be given to
No,
substitute.
anyway, because some people may collect the order and they may think otherwise. Let them come before the court.
Let them appear in any case on the writ petition also notice are to be issued.
Yes.
Let the notice be issued in this matter.
Yes, only my claim by the impugned order of eviction is staring at me, and the Tahsildar of the concerned locality is interim order was there up till the disposal of the writ petition.
Since 2022, you have filed the appeal, like.
No. 20. Eviction order of eviction stares at me.
You have filed any application?
First time, IA number
3809
2145.
2145.
In I 2145. Citizens. Issue notice. Returnable on the same date. This just replicate the order. Verify also and the other steps for sentences. Meanwhile, the status quo. With regard to the case of the land. Can you give the description of the land?
Yes, that is there in the land schedule, page 15. It was there. You will see a case land in the
land under the land which is the subject matter of the appeal shall be maintained by the parties. The position of the land shall be maintained by the parties.
I prefer urgent copy.
Urgent certified copies.
Item number 6.
Well, there's a delay of 344 days.
Why? Why such 1 year delay for the government? Definitely some contempt proceeding has been filed by the party and you have come out of your slumber. That is the case. Anyway, we are issuing notice. Issuing notice on
Case of regularization.
You have also not filed the certified copy.
We'll file it in the certified copy. We already have, Your Lordship. We'll file it.
Already filed it. In I number 2542. This is an application for condoning the delay under section 5 of the Limitation Act for condoning the delay of 474 days in preferring the intercourt appeal from the order dated 13 December 2021, passed by the London Single Judge in WPC OSC number 18054/2002. Issue notice as to why the aforementioned delay shall not be condoned, or any other order or orders esteemed fit in the circumstances of the case shall be passed. Notice is made returnable on 30th of October 2023. Steps for service of notice on the opposite party shall be taken by the appellant of the bench within 3 working days from today by registered post daily. Next.
Item 7.
Yes.
Item 7, my lord, there is a noting that certified copy has not been filed, my lord, because I have filed the downloaded copy, my lord. And I am filing a petition today also for this. After seeing the noting, I am filing a petition for dispensing the filing of certified copy.
Because not filed.
No, my lord, today only I have called the client.
Taken on 5th of October.
My lord, because it will be infructuous by that time, because now while
My action doesn't show that you have any concern.
my lord, because I have filed I thought the digital signed copy I have filed, for that reason
It is not certified.
because while my writ petition was pending,
It will be taken up on 21st. Let us try.
18 May, I pray, because they are going to
Application, even you file the application.
file an application for I have called, I filed by within half an hour, my lord.
Today, half an hour.
My lord, because I have made ready.
List it tomorrow at the request of you are Mr. Biswal.
My lord, my lord.
Mr.
Because I have called the client and
we are not observing anything.
my lord.
You file.
Item number 8.
Lordship, item 8, pray for.
Looking at 12. Mentioning to be taken over at 12.
12, submit 12.
Item 9.
Earlier matter, are you appearing in this?
My lord, 8. I'm not appearing in 8.
No, not 8.
I'm in 9.
7, are you appearing?
Yes, 7 I'm appearing. But there are private respondents.
Oh, no, we are only to given time for him. Already. Yes.
Item number 9.
It may kindly remember last date, many lawyers made submissions regarding draft policy of Chilica. That we have not formulated the policy despite the orders of this. I will draw your lordship's attention to the order dated 15th May 2023. Your lordship may kindly have a glance. 15th May 20 of this case. 15th May. Item. 15th May, para 3.
Yes.
Your lordship got it. Para 3.
Yes.
The court directs that the approved draft policy be placed before the court within a period of 6 months as assured by the government. So 6 months is expiring in November 15th. So before then I will place before your lordship another document. Yesterday I have received from the government. There is in the meanwhile, lot of developments are there. There was a meeting and the minutes of the meeting held in the conference hall of R&DM department on 7th September 2023 under the chairmanship of revenue obtained the views of different stakeholders on draft comprehensive policy for fishing in Chilica furnished by Chilica Development. So we are on the process of preparing the draft policy and the target your lordship has fixed till 15th November. So I'm just placing this instruction which I have received from the government. Hey.
Lordship, I am in virtual lordship. I may be permitted to mention submit lordship. In this case, the draft approval policy that will not in any way help for maintenance of the ecology lordship. The main problem is that, Lordship, 1/6 of Chilka is being nowadays
What is
covered
the
by.
purpose of, no, just wait, Mr. Biswal. What is the purpose of that framing a draft policy?
Lordship, that draft policy copy is with us. We have got it. Lordship,
You have
in
not
this
even seen the draft policy and you have made a comment.
In that
You have not seen the draft policy, let the draft policy come, go through the draft policy, then raise your objection, challenge that if you are not satisfied. Without seeing the draft policy, you are making allegation.
The problem is that 1/6 of the Chilka is being covered by bamboo grass. They are not addressing to that issue. Second is that inside Chilka, Lordship, there are 11 islands. Each of the island has been connected with the road. As a result, the water is not sinking. If the water will not sink, then the oxygen level in the water will reduce, and the Chilka water will be poisoned. All these are major issues they have not addressed, which they should address in that policy. Thereafter, Lordship,
Policy has not been finalized. Their submission is very categorical that we are having introduction with the stakeholders. If you want to participate in the policy framing, we can give the liberty, you file your opinion, go and have a collect a copy of the draft policy, make your comments on the policy.
File your objection.
File your objection or your opinion about the policy.
No, I think he is appearing for one of the stakeholder.
Yes.
no,
He's-
for hundreds of farmers. Mr. Mahanti, government advocate is stating that he is only one. I am appearing for hundreds of farmers. That is all.
I am always.
He said one of the stakeholder. He
I
has
say
not
that
said one.
for the
One of the
stakeholders.
stakeholders. There are many stakeholders.
Yes,
But
Lordship.
those stakeholders are being.
But Mr. Mahanti, earlier there was also direction in this case, if I remember,
Yes.
for removal of this enforcement.
That going on.
There was a process. That was one.
Last date, many affidavits, your Lordship may kindly see.
The main allegation is with regard to that.
Now,
Whether you are taking steps for removal of these enforcement.
yes, that is going on. Their main contention is that the policy should come up. Then everything can be set right. Now we are in the process. We will file the policy. November 15th is the target date fixed by
Yes,
the.
Mr. Biswal,
Lordship,
why don't you appear before the government and put forth your opinion? If you have any good suggestions, they will definitely consider.
Lordship, there was a meeting of the farmers in Ponapadia, that is in Parikud, Lordship, in the month of August, Lordship. In that, all these farmers, they stated that the government, what the policy they have formulated, they have not taken into confidence to the farmers, Lordship. Our main contention is that they should have only consult with the persons, those who are there in their line.
You are not in their line. We believe that you are not in their line. We are granting you the liberty. File a copy of the draft policy. Mr. Biswal, it is useless to elongate this discourse because the court has given the 6 months time and that has not elapsed as yet. So if you want to participate in the introduction of the draft policy, they have already prepared. We are granting you liberty to go through the draft policy, file your considered opinion, where the changes are to be made or anything new to be incorporated in the policy, you can do that.
My lord, what he himself submitted, there was an interaction with the farmers in Parikuda, and these things are going on.
What is a litigation?
They can file representation.
Biswal, have you understood what my lord just said?
They are demolishing our ponds. Our
Mr. Biswal, have you understood what the minor TJC has said just now?
Lordship.
Just go and appear, file your opinion or suggestion. If they don't consider, then you come. That this was my suggestion, opinion, they are not considered while preparing the draft policy. So I think is also premature.
We have
When
given
something has
right
come,
to
has not seen the light of the day.
and to the fisheries department, to the revenue department, we have given it writing. The main issues they are not addressing. For maintenance of the ecology, Chilka need coconut.
Why don't you, Mr. Manvi, why don't you conduct a joint meeting?
These are major issues.
There are interaction meetings, and these points are also taken care of. And if my learned friend wants something, that they should give a representation to the secretary so that can be taken note of.
Chilka Development Authority chairman, the representation is pending. The main issues they are not addressing. Bamboo grass eradication, polythene banning, then the road connected that the water is not sucking. That is the reason they should have made the bridge for the movement of the water inside in that all those island areas. These are the major issues which they are not addressing. And we the poor farmers, we have cultivated our land, somewhere some fish cultivation. They are demolishing our ponds.
All right, for the time being, we are giving you the leave to file your opinion before the committee which is considering the draft policy for modification.
Lordship.
Yes.
Have you gone through these minutes of the meeting? Provide him a copy.
Yes, I can provide. I am having one.
Go through these minutes and
Lordship.
file your suggestion. Participate in that meeting.
Lordship.
My lord, before that, my last matter, WPC 23877. 23877.
Dinabandhu ki?
Dinam.
That has to be detached.
Because
on each and every occasion, I just place before a lordship that it should not be tagged with.
Somebody has tagged it. We have not.
It is to be
But
kind.
only lordship should know that. My lord, this is a dispute has arisen after bifurcation of the reorganization of the.
My lord, that will be a great confusion if.
Please let me complete.
Why you are interfering? That is a different case. Which is no, I am not saying to so I raise that while hearing these matters, your lordship may separately
Not opposing them. Mr. Mohanty is not opposing.
So no, I am also saying that that subject matter may not be placed now because it will create confusion. Because lot of lawyers have.
So that is why I your lordship call for on my mentioning that I am may be allowed.
Let the I come.
I have.
Well, we will take up after the order passed in this detailing your matter.
Yes.
What is the number, Mr. Mohanty?
23877 of 2021.
Last matter. That are
It
four
is
matters.
only to be detached and your lordship may fix it to
In
any.
other three matter, one of my matter is there also. In other three matter.
Yes, that you can place.
Outside is submitted that
Will be covered.
by the order dated
My lord,
of May.
pardon, my lord, I have 6 writ petitions tagged to the. Here, my lord, Coastal Aquaculture Authority of India has not yet decided, though recommendation has been made by the district level committee
Yes.
for granting the registration, my lord. Your lordship is directed again and again to consider the application of pass appropriate order. Included the appropriate order has have not been passed, my lord.
Mr. Mahathir, earlier that the direction you are saying.
Yes, direction was there.
If they are not carrying out the order, why further direction? Already direction is there. So only order is to be executed. You file contempt.
Let me clarify which order my learned friend is saying. Already instruction was made. We filed the affidavit in this respect. For the
Petitions.
yes.
You have not given me the copy.
This WPC number 7469 2017.
769 of 2007. Give me a copy to me.
Another copy.
Gupta has given copy to us. Very categorical. Have you supplied or you not supplied copy?
Given. If it is not given, again will be.
Have you received copy?
No, my lord. I have not received.
Some a copy, Mr. Mahathir.
What is your stand in that affidavit?
We'll make it the Xerox and give it to it. Course of
What the stand that you have taken in this affidavit regarding the registration?
Correct. As regard to their
And interim orders have been passed by this honorable court, my lord. Not to take any coercive action against that upon getting up.
If they are violating, it is open to you. You can always file a contempt application.
The interim order may be extended, my lord. Interim order is conditional that we will not demolish that. But we will not be allowed. We are not cultivating, my lord. Obeying the order of this honorable court, we are not cultivating at all.
Only consideration of please stop on that. Side of that.
Yes, the government has been recommended on the state level committee constituted. Accordingly, the Judicial Authority and State Authority is taking all sort of steps in this regard. And whoever coming with the application, that is the prerogative of this district authority because statute says it. The state level committee, we have categorized this who is the chairman, who is the members. Then they will educate. I think necessary order in this regard. That is in the acted upon directly. We have already recommended the application. Let it be considered. You will also directed the Coastal Aquaculture Authority to take a decision by this special.
What is the problem in taking a decision?
You may grant.
What is the problem? Why is it pending?
Power of the district. That's why the.
Right, because statutory committee is there.
Yes.
The committee should take it.
The chairperson.
That committee is in the direction.
The committee, the recommending authority.
My lord, so far as district committee is concerned,
Collector has already comment. They have recommended authority the appropriate.
As per the statute, who will take the responsibility?
Coastal authority.
Saying that
Same in injunctions of rejection to file fresh litigation. How well is entitled to get the registration. Accordingly, you will decide and dispose it.
My lord, because according to the petitioners, they have already submitted their application for registration and that has been routed and with recommendation.
Yes.
But you are sitting over this file.
Yes, my lord. No, whatever application we have
Yes.
already it is disposed of. My instruction with this. Suppose any.
No, well, we are giving a time frame now. 30 days you dispose of all the applications.
Yes, sir.
All right. And your petitions you are disposing of.
Yes.
With liberty reserved, if you are agreed by any order passed by the authority, you can approach the court again.
yes, that observation is there, my lord.
All right.
My lord. That
You will
is
also may observe that, my
With
lord.
that, it will be disposed of.
Yes. And my lord, till then, my lord, no coercive action shall be taken.
they are already there. So,
Obliged.
So last occasion also directed to submit the Chilika policy. And Lordship,
There is a problem because the order dated 15th May 2023,
Lordship,
this court provided 6 months time and this will be over in the month of November. So we cannot blame them, but they have produced minutes. It
I have
shows
given a
that
copy
they are
to you.
already having the interaction of their stakeholders, taking their opinion, and at one level they have further committee they have gone to finalize the draft policy also.
Number 2.
Just Mr. Mohanty just supply Mr. Dolly.
I have given the person who was agitating this issue last date.
There. So file another affidavit explaining therein that how many applications we have.
Application reached you, there is no responsibility of discharging those applications. So those who have received through the channel, that only you will decide within 30 days.
Exactly.
so Pari, what my lord is saying, you can't sit over the application.
Yes.
If such applications are there, you have to dispose it of in a time bound manner. Can't sit over the matter.
Already you have
Lordship,
another 30.
Lordship, another two provisions, Lordship. So for this policy is concerned, pursuant to direction of Honorable Apex Court, in absence of policy, they are taking now, Lordship, eviction, demolition drive, Lordship. But now, by virtue of this, getting the advantage of 6 months' time, now we would encourage the Chilika policy, from culture in Chilika, enter channel and outer Indian channel. That is being blocked. So, Lordship, it is a great threat to the traditional fishermen. Because by way of this embankments in the outer channel and Indian channel, Lordship, now with this traveling of this Lordship, this ship from seals and this fish seals is not possible. So that's why Lordship, the fish landing is drastically reduced. So it is a threat to traditional fishermen. They should promote it.
Let Mr. Mahanti take the instruction.
Yes, my lord.
Have you brought this on record?
Yes, that is their Lordship. They are submitted to happen.
We will take instruction on that.
Outer channel and inner channel, that should be also become future because otherwise the passage of Lordship, this.
All right.
That is IA number.
I am leaving. Mr. Gupta is on.
And then second grievance, Lordship, can you come to read application number 4539/2018? That is petition is Sudhan Shekhar Vishwa. 4539, yes.
That your file है ये.
Lordship, in 453 Lordship, here the allegation Lordship, they have set up 3 HEDs. Lordship, only they have created this Lordship, production of this prawn HEDs Lordship to encourage prawn culture. And all these 3 HEDs in Lordship adjacent area, that is the regional forest area.
and persons lordship variation, they have demolished once or twice lordship. Now lordship by this taking advantage of the adjournment, now lordship they have again then started the from culture, from production of this.
You bring it to the
Lordship there, now lordship there, huge nexus lordship. You come, I have approach lordship, I have not lordship. Perhaps every I have copy letting for take file is reply to that. Lordship can see lordship by saying so you have to give them an opportunity to record lordship. How can they to submit lordship? Because lordship doesn't directly deal for wildlife to take action once he is taken action. Only take instruction from the DFO, it is offense. Because lordship direction is there. Every opportunity for lordship.
May I submit one thing to my lords? He has raised two grievances. Kindly provide me the IN numbers relating to these two grievances, and I assure your lordship.
That is a donkey.
That IN number should be noted in the order.
Can you just refer us to the repetition number again?
Lordship.
That is at page 40.
Lordship, that is 4, 5, 9 of 2018.
Lordship, I'm sorry to submit lordship. If the hatcheries will be stopped, the farmers will be in secure bad position, lordship. We are importing prawn seeds from Andhra and
Wait, Mr. Vishal, we are dealing with one matter. Have patience.
Government particles. अच्छी अब अच्छी
for construction
Union of India pa এটা আমু গলতি দেই না এটা দিলে কোন হবে read
it has become difficult for the traditional fishes man
my copy has not been
to have the prawn landed stop. Mr. Golden Council has emphatically stated that inner and outer channel should be declared as the free zone. Is it in demand? Stop. At this juncture, Mr. D.K. Mohantil and additional government advocate urges short adjournment for take the instruction. Paste and sell out. Let the matter be listed. The matter will be taken. Let such instruction be received by the next date.
May I request Mr. Dole to provide a
Yes,
it's not available.
So that will be easier for
Sir,
when your lordship is listing,
File in this a copy of the interlocutory application.
it is the writ petition, I think.
Copy of the repetition is supplied to Mr. Mohantil and the council in the course of the day. Right?
Lordship.
Lordship, from the inner and outer,
453 some observation. Lordship, original writ application, outer channel eventually original writ application, that's the 7469. For 4539, that hatchery part is concerned, Lordship. That's
okay. Both will respond.
That 4539 is that allegation.
Allegation.
The removal of then of removing.
Lordship.
So here we pray for removal. Okay.
You are not for the free zone.
No, in original writ application 7469, and I'm for entire Chilica Lordship. I'm repeating for traditional fishermen's Lordship. So I require Lordship, I need Lordship to free zone of that inner and outer channels Lordship, because that is being
petition.
That is original writ application Lordship
7539.
4539 is this one.
Yes.
453.
The allegation is that continuing with the
yes, ma'am. I understand.
Lordship, the cost of importing the prawn seeds would be
one matter.
Lordship, if the hatcheries will be stopped, those who are doing it in the natural way, that will affect severely to the prawn cultivators of the Chilka across Chilka, Lordship. And in that case, people are dying without food in a state, Lordship. And if all these are
we are not passing any order.
Lordship.
We are allowing the state to respond to the allegations.
Lordship, as a lordship.
Kindly give me 3 weeks time.
That you means to say this 7469.
7469 is required for 3 your lordship for out of 10 channel.
All right, this is the first case. All right. What are in that case? Huh? And what is your prayer in this next case?
4539 is illegal hatcheries in prohibited area lordship, that is in reserve forest area. That was lordship passed to demolish the sir. That is twice demolished. Now again they have lordship reconstructed.
All right.
Lordship.
WPC number 145. That is your number is
In that,
4539 lordship.
4539.
4539.
4539 2018. Mr. S.K. Lovil and counsel appearing for the petitioner has made a serious allegation that despite the removal of the hatcheries more than once, again some persons,
Same person. Same persons.
again the same persons has been trying to put up the hatcheries.
Emergency
We were directed to remove these illegal hatcheries. We reiterate our direction also to remove the illegal hatcheries. So there should be a surveillance so that the illegal hatcheries cannot come up after their removals. A copy of this order is finally all took together and stuff.
Grateful.
Lordship, nowadays our problem would be, Lordship, where we'll get the prawn seed, Lordship. If
That is
by
what
your-
government will take, because we are just reiterating our old order. We are not passing any new order.
Lordship, we will be in the problem, Lordship. We
All
will
right,
be-
all right, all right. We have heard you.
Lordship, government may think of it in alternate. They can also do some hatchery where-
You file an application for the alternative. We are not deciding on the alternative. You are violating our direction, and the violators cannot claim equity before the court. Stop generally, huh? Your lordship will appear for the parties. Where is Mr. this? Mahanti, what is his matter? 6 matters he was pointing out.
Yes, that is important. 6 matters can be disposed of because
Yes. All right. These 6 matters. Separate order will be there. Mr. M.K. Mahanti. Manoj Kumar Mahanti, learned counsel, has submitted that the therefore registration of the writ petition has been scrutinized by the district level committee and favorably recommended for their registration. But the central authority, what is the name of the central authority? The
Central Aquaculture Authority.
Central authority, namely Coastal Aquaculture Authority, has not been issuing the registration. They have not taken a final decision on the prayer for registration. Mr. B.A. Gupta, Central Government Council appearing for the said authority, has submitted that they are in the process to take the decision. Having regard to the time consumed already by the said authority, we direct appropriate decision on the registration be taken by the central authority within 30 days from the date. So, if the petitions are agreed by any decision of the central authority, raise the liberty to approach this court again. In terms of the above, all these petitions, the 6 petitions, stands disposed of. Next.
Your Lordship, in the main writ petition, a wide order dated 16th of January 2023, the Lordship had directed the state government to deploy drones and to monitor these earthen and embankments in the water, and also to provide a status report before each and every date. So that they may be directed to do, because they have not yet responded to that, how far they have deployed that drone technology.
All right. Last year this. By the order dated 15/5/2023, this court had directed this, what is the department these are working on this?
Revenue and disaster management.
Revenue and disaster.
The Revenue and Disaster Management Department to frame a policy.
Draft policy.
All right, frame a policy. Comprehensive policy for fishing in Chilika. Stop. In this respect, Mr. Mohanty, Additional Government Advocate, has produced before us the minutes of the meeting. It was held in the conference of the Revenue and DM Department on 7/9/2023. Stop. From there, we can discern that already initiatives have been taken for framing the said policy. Stop. The Chilika Development Authority has already prepared a draft policy, and on the basis of the said draft policy, the interactions and consultative meetings are being held with the stakeholders at state level and district levels. For purpose of finalizing the policy, a committee has been constituted. Mr. A. Bishwal, Land Council, who is appearing for the fishermen, has contended that at no level the fishermen were afforded opportunity to have their say. It is understood that objective of the draft policy would primarily focus on the fishing activities in a responsible and sustainable manner, considering the long-term interest of the people in and around the Chilika region. We feel that there should be consultation with the fishermen's representative. So at the juncture, Mr. Mohanty, an additional government advocate, has apprised us that in 2 districts, there's 3 districts, namely Khordha, Puri, and Ganjam. Initiative has already been taken to have the views of the stakeholders, including the fishing community. We grant liberty to Mr. Biswal and Nancy, who is representing a section of the fishermen,
Stakeholders for it. Perhaps appearing for stakeholders, not for stakeholders.
No, he is only interested about the fishermen. Traditional fishermen.
In fact, also we are appearing for traditional fishermen. We are interested for.
A section of traditional fishermen. He is claiming.
You are appearing, he is also appearing for.
You are also. He is claiming. That is why I am telling you that you may also. You may also.
Because I am appealing for non-fishermen.
All right, you can also. Everybody can. All right. To submit the suggestion on behalf of the traditional fishermen and also the comments on the draft policy as already prepared by the Chilika Development Authority. So we'd request Mr. D.K. Mohanty and Council to direct the additional Chief Secretary to the government who is looking after the framing of the draft policy to supply a copy to Mr. A. Biswal and the council of the other stakeholders to have their say on that draft policy. All the stakeholders will have the similar liberty as granted to Mr. Biswal and to place their suggestion and comment on the draft policy. But that shall be filed before the 10th of October 2023. It is made absolutely clear this is a very rigid timeline as this court has granted the authorities to finalize the draft policy by 30th of November 2023.
Yes.
That's all I think for the time. So, you know.
That's
Let's see.
Only may, Malad has indicated traditional fishermen. Malad may indicate that non-fishermen also.
So all the
What's the stakeholders?
That what traditional fishermen. That is, Supreme Court has already decided it will be settled 60-40 ratio.
That was into before consideration, but my lord has.
all the stakeholders, or to get the similar liberty, you can also file the position in certain sense. And Mr. Mohanty will be the facilitators of filing the draft. A copy of this order is supplied to the council for the parties appearing in this matter.
Lordship is fixing the next date.
10th October.
After 10th. No, it will be fixing on the
November.
after December, sometime in December.
Lordship may fix this matter in November because December will be due.
Last week of December is better.
4th December.
4th December.
Demolition drive should not be stopped in the meantime.
Demolition drive is going on.
Right, that's
Going on.
That you should pass an order to not to.
This order cannot.
Because Lordship, by taking advantage of this long.
We are passing specific order to just remove this kind of.
Who is taking advantage of this long adjournment? We are doing. We are doing.
What is your matter? Just point out.
Well, I have filed an IA. IA then 916.
What is your repetition number?
23877
That is to be detached.
of 21.
Page 15.
23877.
Yes. In WPC 3877 of 2021. Council for these the parties have stated in unison this matter cannot be treated as an analogous matter and has this matter stands detached. It shall be listed separately henceforth. What is your IA?
IA is the amendment.
Stop. This is a separate order. You just pass. No, not good. Not in the part of this order. Completely a separate order. In WPC 23877. What is your IA?
IA number is 9168 of 23.
Give the IA.
It's me.
Just open it.
Flag D.
Flag D.
9168.
Mr. Mohanty, I think this can be allowed. You get the opportunity of filing the counter affidavit.
I have filed my counter affidavit.
The additional counter affidavit, they want to incorporate certain more materials now in the writ petition.
In the writ petition.
All right. In IA.
Then we will file additional affidavit.
That will give liberty. There is an application for amendment of the writ petition being WPC number 23877 of 2021. It has been stated in the petition that some material facts could not be made part of the writ petition, but those are highly essential for adjudication. We have produced the schedule of amendment appended to this application and also heard Mr. P.K. Mohanty, the senior counsel, who is esteemed. Excellencies. Also heard Mr. D.K. Mohanty, learned additional government advocate, who has not raised any objection, but he has categorically stated that the state opposite party shall be granted opportunity to file the additional affidavit.
Additional counter affidavit.
Additional counter affidavit after the consolidated.
After the consolidated petition is served on me.
Okay, served on that. So, in view of the above, we allow this petition to incorporate the proposed amendment in terms of the schedule of the amendment. So, the petitioner shall file the consolidated petition within 15 days from today. So, thereafter, the state opposite parties shall get a month's time to file the counter affidavit. Let the matter be listed on the 6th November. Mid of November. 15th November 2023.
So far as that Ron-Ghiri matter is concerned, a copy of the order may be.
To all every past order, to all the council, copy of the order will be supplied.
In the main matter, that one direction needs to be passed by your lordship's order dated 16 January.
Drone surveillance matter. Big matter. It has been pointed out by Mr. Mohit Agarwal. You are the amicus.
Yes, Your Honor.
Amicus query that the 6th order dated
16th January 23.
By the order dated 16th January 2023, this court directed to initiate the drone surveillance over the Chelika for violation by the various vested interests and its aqua and eco status stopped. But we have not been apprised what action has been taken on the said order dated such and such. Mr. Mohanty and Counsel is directed to obtain instruction from the competent authority.
And file affidavit on the next.
Yes. To file a short affidavit on the respect of the matter by the next list.
Item 8, sir.
Yes. Lordship calling this matter on 4th December, Lordship.
15th December.
My lords, this is a matter relating to the PF Act, Your Lordship. I have made a compilation, Your Lordship.
Is it appearing for the commissioner?
And Mr. Mishra is there for the commission. Yes.
We are both for the petitioner, Mr. Mishra and myself.
There are two sets of writ appeals, Your Worship. In 19, I am appearing, first 19. Thereafter, the next 10, Mr. Sahu is appearing, Your Worship. I have made these notes for the entire matter, Your Lordship, all the writ appeals I have made in the notes, Your Lordship. May I please, Your Lordship?
Yes, yes.
In the present appeal, the common judgment passed by the Honorable Single Judge is under challenge, whereby while disposing of the writ petitions under erroneous consideration of facts and laws, peculiar relief has been granted to the undisclosed member, which was no one's case, Your Lordship. Now, Your Lordship, certain dates which I have indicated along with the enclosures, Your Lordship. 4/5/1998, 7A order was passed by RPFC, Regional Provident Fund Commissioner, unilaterally assessing contribution for undisclosed public unidentified employees for the period from 1/95 to 11/97 in respect of 5 establishments. These 5 establishments are represented by Mr. Sahu, Your Lordship.
Yes.
That is enclosure 1, Your Lordship. Your Lordship, may kindly have a look at that enclosure 1, Your Lordship. There is the order dated 4/5/98, Your Lordship. 2 pages order only.
Give the PF fact. Yes.
Madam. Whereas the employer in relation to Messrs. BD Supply Company, Khetrajpur, Sambalpur, covered under the Employees Provident Fund and Miscellaneous Provisions Act 1952 and bearing code number OR 938 has failed to remit the Provident Fund, family pension contribution, EPS and administrative charges, employees deposit linked insurance contributions and employees deposit linked insurance administrative charges due for the months 1/95 to 11/97 within bracket balance. Balance means differential, Your Lordship.
Yes.
In accordance with the provisions of the Employees Provident Funds and Miscellaneous Provisions Act 1952 and the scheme from Bharat. And whereas for the purpose of determining the amount due, the employer was summoned by notice number so-and-so dated 11/2/98 to appear before the undersigned on 3/3/98 to represent his case. During the period of proceedings, nobody remained present on behalf of the management nor submitted any written submission except up to petitions 3/9/98. Although, in order to provide reasonable opportunity, the proceeding was reduced to 2/4/98 and 4/5/98. Hence, I do not think it proper to prolong the proceeding any further and determine the dues on the basis of report of the EO squad submitted by letter number so-and-so dated 21/1/98. Now, I, N.K. Prasad, Regional Provident Fund Commissioner, Raurkela, in exercise of the powers conferred on me under Section 7A of the EPF and MP Act, and having applied my mind to the case, hereby determine the said amount under on account of Provident Fund, Family Pension Fund contributions, administrative charges, so and so, for the months of 1/95 to 11/97, and direct that proceedings for recovery of the amount in accordance with the law be initiated. Thereafter, he has given the table, Your Lordship, who's determined how it is reached and in which account, how much amount. Total, Your Lordship, comes to the last one, 9,07,890. Thereafter, Your Lordship, I may turn back to the note, Your Lordship, 18/7/2021. Because the petitioners or the establishment, they filed a review application before the same authority, Your Lordship. Section 7B, that is the review. Order on review passed by the RPFC confirming Section 7A order on assumption and presumption and decided on documents extraneous to the PF Act. That enclosure is enclosure 2, Your Lordship. And number 2, enclosure 2, Your Lordship.
They have confirmed that order.
Yes. Yes, confirmed the order. Yes, confirmed the order. So may I place the entire note? Thereafter, I will go to the documents if you permit, Your Lordship. Then, Your Lordship, third is establishments preferred appeals under Section 7I against the order on review, which were subjected to interim statutory deposits. Your Lordship, I kindly note this, because unless the statutory deposit is made, the appeal cannot be entertainable, Your Lordship. 28/7/2003, order passed by EPF Appellate Tribunal directing return of the interim deposits with interest while setting aside the assessment orders passed under Section 7A and 7B. Both the orders were set aside and we were directed to be refunded the amount which we have deposited as interim deposit. Then 5 establishments
filed WPC number so and so seeking refund of interim deposits. This is represented by Mr. Sahu, Your Lordship.
My case,
Yes, as directed by the appellate tribunal because they didn't refund the application, the money for more than 2 years, Your Lordship. Then PF department filed WPC number so and so, again 5 petitions challenging the order of the appellate tribunal. After 2 years, correct. Then 17/4/2003, then fresh order under section 7, this is with regard to my case, that is 10 writ petitions, Your Lordship. Fresh order under section 7A passed by the APFC, that is Assistant Provident Fund Commissioner, unilaterally assessing contribution for undisclosed or unidentified employees for the period from 12/1997 to 3/2002. That is the subsequent period, Your Lordship. That was the initial period, this is the subsequent period. In respect of 10 establishments, that is enclosure 4. 10 establishments referred appeals against 7A order, which were subjected to again the interim statutory deposits. And this, in this case, Your Lordship, no 7B recourse was made, Your Lordship. Review was not made, Your Lordship. Then 3/9/2007, order was passed by the APF Appellate Tribunal under section 7L, directing return of interim deposits with interest while setting aside the assessment under section 7A. That is enclosure 5. Then 9 establishments, because the last one establishment could not file, 9 establishments filed WPC numbers, that is 9 numbers, seeking refund of the interim deposit as directed by the appellate tribunal. Your Lordship finds that after 3 years we have filed this writ petition, Your Lordship. And the PF department also filed after 3 years, then 10 writ petitions challenging the order of the appellate tribunal. Now, 25/2016, all the writ petitions were heard together and the judgment was reserved.
Appellate tribunal's view? What is the appellate tribunal's view?
Appellate tribunal crossed the 7A order, Your Lordship, and directed refund of the deposit as has been done in the first case, Your Lordship. That is the view. It's consistent view has been
Why
taken.
have you challenged that order?
I haven't challenged, Your Lordship. The department has challenged.
PF department.
Yes, they have challenged. Yes, they have challenged.
No, some writ petitions have been filed by the establishment.
Yes, they filed because the refund was not given.
Oh, for the
Refund.
challenging the merits of that.
No, not.
Just were report application, which are writ petitions, they are also praying for report of 5 years. And in fact, they have not challenged until up to 2 years. Well, cabinet application filed before this whole court. After getting cabinet intimation, then they came forward after 2 years to file it before Your Lordship.
Right.
Anyway.
Then, Your Lordship, this 1/7/2016, that is the impugned judgment, Your Lordship, here in all the appeals. The writ petitions were disposed of by common judgment, while the writ petitions filed by the establishments have been dismissed. That means our writ petitions have been dismissed, seeking refund of the application. The writ petitions filed by the PF department have been allowed.
Refund of the interim deposits.
Yes.
That writ petitions were dismissed.
Yes. And writ petitions filed by the PF department have been allowed on total misconception of facts and law, with statutory deposits being construed as contributions made by the establishments in favor of undisclosed workers and directing the department for identification and disbursement of the said deposits. Which deposit we had made as a statutory deposit, that has been now directed to be refunded and disbursed to the undisclosed persons, Your Lordship. Your Lordship, submissions, I have made some submissions.
What do you mean by the undisclosed person?
No, they are not identified, Your Lordship. No person's name has come in the proceedings.
During these initial, no, before issuing notice, there was no inspection of the.
No, my lords, no inspection.
What
On the basis of the inspection only.
No, the inspection with regard to a register, which is an excise register, which says that so much of VDs have been removed. And
there is no employee's name.
Is there. That doesn't contain any employee's name.
Response to the specific allegation made against them.
My lord, they have concealed everything. They didn't follow.
They have concealed everything, but the such 7 order cannot be passed without identifying the employees.
Yes, documents are with us.
Great statement. We want. Did you have the list of the employees?
My lord, 7A3 of the Act clearly stipulates that we can do it. My lord, I'm reading it out.
You can do it. Nobody is objecting to that, but you should know what is the employee.
Whatever available documents.
Read 7.
7A, Your Lordship.
That is quoted at page 16 of the impugned order, Your Lordship, entire 7A.
Sir, the employer, employee or any other person required to attend the inquiry under subsection 1
Yes.
fails to attend such inquiry without assigning any valid reason or fails to produce any document or to file any report or return when called upon to do so, the officer conducting the inquiry may decide the applicability of the act or determine the amount due from any employer, as the case may be, on the basis of evidence adduced during the such inquiry and other documents available on record. And he is supposed to keep everything.
You are reading which section?
3A, 3 capital A.
7A, 3 capital A.
3 capital A. 3 capital A.
Yes.
That's only available with us.
Without assigning any valid reason.
Yes.
Yes.
Have you adjudicated that before assessing the liability? Whether the reason given by them was valid or not?
My lord, para 36 of the scheme, para 36 of the PPF scheme that reads out that the duties of employer, and 36B is the duty of contractor.
No, just what is the purpose of that provision? You read it properly. Entire provision you read.
My lord,
There are the 3 purposes for this provision has been enacted. First purpose is to whether this act itself will apply in the cases taken by the commissioner. Second, whether the amount that has been proposed to be determined and suggested to you is due from you or not. That is the second question. And on the basis of that, whether the liability can be fixed, and then the liability will be fixed. Right? The 3 purposes. But the question remains, how can you determine who do not know the number of the workers?
yes, my lord, we determine it on the basis of the quantum.
Money is not important. It has to be deposited against the individual account.
That's the whole point.
My lord,
That money, whatever you just realize from the owner,
yes.
then that you have to deposit that money in the name of the account of the worker only.
My lord,
Member employee.
Yes.
Yes.
Passbook balance.
Yes.
That will deposit.
Yes.
SG12A and SG12B. That was filed before the as per Central Excise and Salt Act 1934. They have submitted the said document, and in that said document, it was stated that this amount is shown. That amount is, and on the basis of that amount,
You can retain the amount provided you come to a conclusion that they are liable to pay such amounts. So for that, you have to follow the procedure. It is to be done in a manner which has been prescribed by the statute. In the same manner or not at all?
Not at all.
When a procedure has been prescribed under 7A, have you conducted, as pointed out by my Lord Chief Justice, the very purpose, 3 categories. Before that, you have to conduct an inquiry. First of all, have you conducted an inquiry or not? Then the second question is whether they were given opportunity of hearing or not. If they fail to appear, the reasons given by them, whether those reasons are reasonable or not. Have you come to such a conclusion? Because it says for valid reasons. 3A. So all these things are there, whether it is there in the order or not.
Several
The absence of all these compliance
didn't appear before the authorities. Several arguments were taken and produced few witnesses, and thereafter, finding no other alternative, we went for publishing the advertisement of local newspaper and made meeting, the local meeting.
Is it there in your authorities order? All these things which you are submitting? Is it there in the authorities order?
Yes, my lord. Finding no.
You can't supplement reasons.
These 2 costs.
The order will be based on the basis of the grounds mentioned in the order.
He is not cooperating. Section 36 clearly enjoins the responsibility.
That order of the authority, come to that order. Is it there? That order.
2 pages only, which I have read out.
That enclosure 1.
Yes. 4598 order.
Now, in fact, in my case, it has only provided reasonable opportunity.
Yes.
Proceeding was adjourned on 2 dates. Hence, I do not think it is proper to prolong the proceeding any further
Matter ends.
and determine the dues on the basis of report, so and so. Is it compliance of that 7A requirement?
No. So that after this order, annexed one, they didn't cooperate. It was again they approached central.
This is the implication. It's a liability. So when the strictly construed.
Yes.
My lord, central to my lord. We again went for case inquiry, and that was not done. They didn't cooperate. They didn't furnish any documents with regard to the.
May I be permitted to complete my submissions here?
Yes,
that will be better here. Because there are 2 sets of writ petitions, 2 sets of cases, your lordship, and 2 periods.
To get clarification, because that will also help you to further dilate your submission.
Yes.
Yes.
My lord, sir, the first which I have read out, 4598 order, that is a 2-page order.
Yes.
As my lord Justice Mahapatra just told, that there is no reason ascribed that why they are now assessing. And they are assessing on a report, your lordship, which is not provided to the establishment. That is a clear violation of the 7A proceeding or procedure, your lordship. That whatever documents you have, you'll have to share with the establishments so that they will come up with the appropriate defense. That has not been done in this case at all.
Defense or explanation?
Explanation, details, whatever, your lordship. That has not been done, your lordship.
Yes.
Then your lordship sees the next enclosure, that is annexure, enclosure 2, your lordship. Because the establishments filed, being agreed with the 7A order, your lordship, they filed 7B applications for review. And this is the review order, your lordship. And you want to find in the review order, I'm placing the BD Supply Company, Khetraspur, Sambalpur, Orissa, after referred as the establishment for debit was covered under the provisions of the EPF-MP Act with effect from 31/1/73 under the schedule head trading and commercial and the code number so and so was issued. The establishment started its manufacturing activities from 53 as declared by the partner in Form 5A dated 11/7/73. A squad consisting of 2 enforcement officers, namely Sri B. Sethi and S.N. Bhuya, visited the establishment on 7/1/98 and verified the records to check up evasion of membership. The squad submitted his report on 21/1/98, which observed as follows. On verification of RG12A register of manufacture of excisable tobacco products, Rule 94, it is seen that the wages of monthly production of BDs as per the scheduled rate are much more than the wages on which PF contribution deducted, which have been contained in 2 separate statements duly sealed and signed by the employer. On the basis of the above report, proceeding under Section 7A was initiated to determine the balance dues for the period from 1/95 to 12/97. This should be 11/97, your lordship. The employer was given opportunities to represent his case and produce records on so and so, so and so. The employer did not attend the proceeding, nor produced records, and hence ex parte order was passed determining an amount of 9,07,890 for the period from so and so as the balance dues by the order dated 4/5/98 of the RPFC Rourkela. In compliance of the Central Provident Fund Commissioner letter dated 15/10/1998, a fresh proceeding for review of the above assessment order dated 4/5/98 was initiated by the APFC Rourkela. The relevant paras of the Central PF Commissioner letter dated 15/10/98 read as follows. Shri Joel Oran, Member of Parliament Lok Sabha, called on the Central PF Commissioner and stated that assessment of dues was done by the assessing officer based on the turnover. Details of the employees were not available. It was contended that even if the money is deposited or is realized, the EPF organization will not be able to, in a position to afford credit to the members concerned, as their names and details are not available. The Central PF Commissioner has passed the following orders. On behalf of the establishment, the employer should give the actual names and details or the actual number of employees who have worked for working. Based on that, the correct assessment should be made. It appears to be a reasonable point, and accordingly on these lines, the officer in charge Rourkela may be advised on the issues and decision taken earlier. Copy to the Regional PF Commissioner, Odisha. one opportunity may be given within 1 month of the details are not received, then further action can be taken by the officer in charge. This intention is not to delay the proceedings and action. Wide publicity may be given in the local newspaper, asking for details of employees and members from other sources also. The amount to be assessed and should be correlated to documentary evidence and other relevant records relating to the payment of wages or all those employees with necessary details. The entire proceeding must be finalized in a period of 3 months. As such, the date of first hearing for review of the case was fixed on so-and-so and adjourned to so-and-so. Then para 4. No one represented the hearing on 17/10/2022 to 11/2000, but on 18/12/2000, the partner of the establishment, Sri Dilip Kumar Saha, appeared on behalf of the management and filed written reply along with a list of 90 workers and PF contribution amounting to 31,679 only in place of 907,890 as assessed dues. On 9/2/2001, Sri Dilip Kumar Saha, partner of the establishment, was present and filed a petition requesting to summon 20 contractors through whom the establishment had engaged BD rollers during the case period to adduce evidence and get information for identification of the workers. The Xerox copies of licenses and registration certificates of those contractors also were submitted. And accordingly, the case was again adjourned to 2/3/2001. On 2/3/2001, Saha, partner of the establishment, represented the proceeding. He produced 4 contractors for examination before me, and each of them filed affidavits which were admitted and made part of the proceeding. Each of the 4 contractors are examined one by one and their statements recorded in order sheet. The representative of the establishment submitted to allow one more date for hearing in order to produce the affidavits of the contractors, and hence the proceeding date was adjourned to 18/4/2001. Dilip Kumar Saha, partner, appeared on behalf of the management and submitted 11 number of affidavits duly signed by the contractors, and the same are also taken part of the proceeding. In the notice fixing date of hearing, the employer was categorically asked to produce relevant records like attendance registers, salary wage payment registers pertaining to both principal employer and the contractors, the RG12 registers, written copy submitted to the Labour Factory Department and Central Excise Department, cash book, balance sheet, so and so, your lordship. Then the records relating to supply of raw materials to the contractors and receipt of finished production payment registers to the contractor, etc. But they avoided to produce all the records in their support. As such, the payment made towards PF dues for 90 employees amounting to so and so 31,679 against 9,07,819 has no base to rely upon to be correct and hence rejected, your lordship. In the written submission, the employer said has raised the following main points to be considered. In the 7A stage, no BD either turned to state his claim nor put forth their claim through application. 7A assessment was made on hypothetical basis and absolutely without any particulars such as name, age, period of work, their earning at the particular period, their address as well as their whereabouts. That the RPFC Rautla brought out an advertisement in the local daily Samad asking all the interested parties to put forth their grievances. Advertisement yielded no result, leaving an impression that there is no claimant for whom assessment could be made. That the RPFC Orissa held a public meeting in the locality on 12/8/1999, in which some contractors attended the meeting and made argument before RPFC not to cover home BD rollers since they are very poor and cannot be able to maintain themselves if the PF amount is deducted. That even though he was maintaining records for the period under dispute, since nobody questioned for maintenance of such records or requested for preserving such records, they have been destroyed. No proper care was taken to preserve such records, destroyed in the meanwhile, and the same cannot be produced after such gap of 5 years. That it is not possible to collect the arrears PF dues from the beneficiaries. Therefore, the employees' contributions may be exempted. That earlier the establishment was summoned for 7A assessment for the period from 2/95 to 6/95, and the matter was settled, and hence the question of further assessment does not arise. That we and CPFC expressed his view in a seminar.
Whether this settlement is recorded anywhere? The 95 to 96, there is a settlement that you are referring to, whether that is recorded?
I don't have it now. I can have it. I don't have it now.
Very important document.
Yes,
If you are claiming on the basis of a settlement.
Yes.
Okay.
That is,
Proceed.
yes, I'll take note of that. That we then CPFC expressed his view in a seminar held in New Delhi on 6/12/97, that where the employees are not traceable, the arrear contribution in respect of them is not required to be paid. This is the note given by the CPFC. Then next, your lordship, how he comes. Now I proceed to discuss one by one each contention of the employer. The first contention is that no claimant turned to state his claim and assessment was made on a hypothetical basis without any particulars such as names and whereabouts of the BD rollers. I do not agree with the contention that assessment was made on hypothetical basis. The assessment was correctly made and it was record based. The employer had not disputed the production of BD shown by him in the RG12A register, that is excise register. The employer had also admitted the facts and he had paid wages to the BD rollers at the rate prescribed by the state government, that is 25 rupees or 27 rupees per thousand, as the case may be. The assessing officer has assessed the PF dues on the differential amount of wages shown in 12AR. With monthly PF returns and wages calculated at the rate of 25 rupees or 27 rupees per thousand, as the case may be. For better understanding, I give an example of calculation of differential wages and assessment of PF dues therein for 1 month, say for the month of January 1995. Production of BD as per RG12A register is 94,26,100. Wages for at the rate of 25 per thousand, 2,35,652. Wages shown in 12-way register PF monthly return on which PF paid 42,903. Difference of wages, that is 2 minus 3, on which PF not paid 1,92,749. So the assessing officer has assessed the dues on this differential amount of wages admittedly paid by the employer to the BD rollers, but PF not paid on it. Thus, it cannot be said in any way that the assessment was made on hypothetical basis. The only main contention of the employer is that the BDs whom the RG12 register were manufactured by him through contractors, and the details of BD rollers are not available either with the contractors or with the principal employer, and hence he should not be asked to make payment of this assessed dues. After the pronouncement of judgment by the Supreme Court in September 85, the law was settled in PM Patel and Sons versus Union of India that the act is applicable in respect of home works employed by the principal employer through contractors. Hence, there is no reason why the principal employer has not extended the PF benefits to all BD home rollers engaged through contractors. The law was settled after the judgment of the Honorable Supreme Court on 3/5/93. There is Nasiruddin BD merchant case. In special petitions of wherein it is held as under. It is open for the petitioner to collect the names of the BD workers who work for them through their contractors and furnish the name of all workers to the Penal Commissioner. That it is the responsibility of the employer to collect the details of workers.
Stand in this regard that it is the responsibility of the employer to supply the names of the workmen those who are working in their.
And it's actually whatever names were there for whom PF has been paid. This is written as if PF is not paid by the employers. But actually, the PF has been paid. He has made out some differential.
I am talking about the disclosure of the names of your own.
What I pointed out, 192 names were disclosed, and for them, 31,679 was assessed. That is rejected. But no, I am not looking to that. So, if you are rejecting one thing, you must come out with the details. But what are the details that you are having, Your Lordship? That is the predicament section 7A, Your Lordship. If I have produced some employees' names, Your Lordship, and the commissioner of the authority rejects it, then he must have the authority or the record to show that what the claim is there is substantiated. That is not done in either of these cases, Your Lordship. Your Lordship, may I now come to the next page, Your Lordship. The third, that is internal page 6, Your Lordship. Third para, Your Lordship, just before para 9, Your Lordship. This is relating to waiver of the employee's share, because I am not going to this because this is not the subject matter of the present case, Your Lordship. 9. As regards advertisement in newspapers, because most of the BD rollers here workers are poor and illiterate, they cannot afford to purchase or read regularly the newspapers, nor they have knowledge to file complaint before the regional PF commissioner for non-extension of PF benefits to them. Hence, on this ground, no relief can be given to the employer, and so this contention is rejected. And this is given by the direction has been given by the Central PF Commission, Your Lordship. I have an advertisement. As regards to summons for 7A for the period for 295 to 695, it is made clear to the employer that a separate investigation for evasion of membership by a squad was conducted as stated in paras above, and basing on its report for evasion of PF contribution and membership for the period from 195 to 1197, a first proceeding was initiated independently. This is the second proceeding, Your Lordship, 1/95 to 11/97. As hence closing of a proceeding up to 6/95 earlier will not prevent 7A authority to ascertain evasion and assess fresh dues, Your Lordship. As to the point, the question which my lords had asked me, that where is that record, your lordship, with regard to the 195 to 5 by 6 by 95, your lord, 295 to 6 by 95, your lordship. This is he is stating that is relating to the correct assessment of the 7A proceeding, your lordship, determination. And thereafter he has again assessed a facet proceeding because allegation is that for evasion of the procedure, the contribution dues, your lordship.
That settlement you are referring to?
It is not a settlement, your lordship. It's possibly an order, your lordship.
No, that settlement you have referred.
Minor.
He has referred in that order.
Yes.
Have they agreed on number of workers they were working at that time?
Yes, because that was clear, yes, that was made, your lordship. I'll produce that, your lordship.
That is very important.
It's important. I'll produce that, definitely, I'll produce it, your lordship. Now, as to the point of mere expression of view by any higher authority on any subject matter in newspapers, it cannot be implemented as law, rule or regulations as long as the same is approved by Parliament and notified in the official Gazette of India. Hence, the contention of the employer, where the employees are not traceable by years of the contribution in respect of them, is not required to be paid, has no legal base and hence rejected. It is also noteworthy to mention here that though the quantity of BD manufactured per month as shown by the employer in RG 12 register for the period from 1 by 95 to 8 by 99 remained more or less same, but the number of workers engaged to whom PF benefits have been extended has been increased tremendously. As per records available in the file, the quantity of BD manufactured as per RG 12 register and number of workers as per 12 register PF returns to whom PF benefits have been extended by the employer is given below for better appreciation of the facts. This was not there earlier, your lordship. This is now given in the review proceeding, your lordship. Yes. And your lordship finds the entire from 195 to 7 by 99, the entire month-wise statement has been recorded, your lordship, in page internal page 7 of that order. Then your lordship comes to the last page, your lordship. On a general and plain overview of the above fact, it is clear that the employer has extended PF benefits in January 95 for 138 workers, whereas the number of workers enrolled as PF members by the employer in 7 by 99 increased up to 823, whereas the production of BD is more or less static. This increase in the membership is my opinion, due to steps taken by the PF authority to determine the PF dues on the basis of RG 12 register and nothing else, your lordship. Wherefrom does it get it, your lordship? Under the above circumstances, I do not hesitate to conclude that the employer is taking the shelter of non-identification of workers only to evade his past liability and not disclosing the names of beneficiaries voluntarily. I do not hesitate to conclude also that the beneficiaries for the period in question, 195 to 11 by 97, for which assessment had been made, amounting to rupees 9,07,890, are none but the beneficiaries who have extended PF benefits by the employer during the period 11 by 97, because it has been established by examination of contractors in other BD cases. As I am conducting the review case for other 9 BD establishments of the same place, that is Sambalpur, on similar issue, that BD workers belong to village or nearby village of the contractors, and hence there will be no difficulty to identify them. That means from this proceeding, he has jumped to another proceeding and he has borrowed the proceedings which are there on record in the other proceeding to this case, your lordship. However, later on the employer has already identified them and extended PF benefits, but not disclosing the facts that these workers were actually working from 195 onwards, also only to escape past liability, because it has been found that home workers in BD industry are stable labor force and not frequent changing. And then the order, your lordship, cryptic order. Keeping in view the above facts and circumstances as discussed in them, I again confirm the assessment order for 9,07,890 for the period 1 by 95 to 11 by 97, passed by 7 authority on 4/5/98, and direct the employer to deposit the dues, your lordship. And again, for these entire thing, what is the identification of the employees? That is not there at all. And that is reiterated here. Same order. And then, your lordship, against these 2 orders, 7A and 7B, the 5 establishments, they filed an appeal, your lordship, before the appellate authority. And the appellate authority order is the next page, your lordship. That is, your lordship finds the order is dated 28th day of July 2003, your lordship. I am starting with page 2, your lordship. The above appeals have similar
in the compilation. This order is in the compilation.
Yes.
It encloses 3, your lordship. That slip is there for 3.
Not been paginated. Internal phase 2.
Okay.
Internal page 2, Your Lordship. I'm starting with internal page 2, Your Lordship. I'm starting with internal page 2, Your Lordship.
All right.
The above appeals have similar or common issue for decision. Therefore, on the request of the parties, these appeals have been heard and decided together by the same judgment. Copies of this order be placed on other files. The Assistant Provident Fund Commissioner passed Order Section 7A of the EPF Act, where liability has been determined against the appellant mentioned in the appeal. The BD establishment situated in the district of Sambalpur approached the Central Provident Fund Commissioner and the Learned Central Provident Fund Commissioner on the assessment of the entire aspect, passed an order dated 15/10/1998, directing the respondent to rehear the matter, giving reasonable opportunity to the appellant. The extract of this letter is reproduced below. On behalf of the establishment, the employer should give the actual names and details of the actual number of employees who have worked or working. Based on that, the correct assessment should be made. On these lines, officer in charge Rautala may be advised on the issues and decisions taken earlier. Copy to the RPFC Odisha. One opportunity may be given, and 1 month. Within 1 month, if the details are not received, then further action can be taken by the officer in charge. This intention is not to delay the proceeding and action. Wide publicity may be given in the local newspaper asking for details of the employees and the employers from the other sources also. The amount to be assessed should be correlated to documentary evidence and other relevant records relating to payment of wages to those employees with necessary details. The entire proceeding must be finalized with a period of 3 months. In compliance of the order issued by the office of the CPFC, an advertisement was given in the local newspaper on 14/12/1998, and the matter was pursued further by RPFC. There is no response to the same from any corner whatsoever. The matter was pursued further by the RPFC. There was no response to the same from any corner whatsoever. Responding Commissioner also organized several meetings to motivate the beneficiaries that also became futile. The appellant's review petition under Section 7B, with the result that the impugned orders under Section 7B were passed whereby liability for the amount of dues has been determined against the appellant for the period mentioned in appeals. This is an appeal wherein the validity of the impugned orders has been challenged on various grounds as stated in the appeals. The undisputed facts of the case are as follows. Soon after the amendment of Para 26 of the EPF scheme, the appellant, during the pendency of the proceedings under Section 7B of the Act of his own, deposited dues in respect of employees. He did not question the right of home BD workers. The aforesaid amount was deposited by appellant as per details of such workers available with them or with their contractors, or on the basis of information as may be available with the appellant. Appellant's case in brief is as follows. Even after he deposited on his own the aforesaid amount on account of home workers, even when the respondent called for records maintained such as RG 12A register, that is excise register, wherein production of BDs has been shown, and this is an admitted fact. However, the respondent previous commissioner mainly relied on the total production of BDs as shown in RG 12A register, and some of the contractors through whom the BDs were got manufactured from home workers. But no reliance has been placed on the submission made by the contractors. He calculated his amount of dues without stating as to how many workers were there, what are their details, and whereabouts, and how the amount of dues has been worked out. The appellant protested that if the beneficiaries are not ascertained, who will get the benefit of the payment of dues? But the respondent PF Commission remained adamant and passed the impugned order. Respondent Commissioner's case in brief is as follows. It has been stated that the appellant and contractors did not produce adequate and relevant records and evidence about the correct numbers of home workers, and therefore he had to rely on the total production of BDs as reflected in RG 12A register. He did not consider the argument of the appellant that mere quantum of BDs prepared and wages disbursed during the relevant period will not be sufficient to determine the amount of dues unless and until the identities and details of workers are procured to whom the amount of dues shall be paid. The appellant argued that as per the EPF and NTR, there is no statutory provisions for maintenance of books of account and registers and the details of these books of accounts and registers thereon. As per the Payment of Wages Act and along with the Payment of Wages rules, the Minimum Wages Act along with the Minimum Wages Rental rules, right now, there is a specific provision on the issue because Payment of Wages Act says that any register is to be maintained for a period of 3 years. It also finds in clause 2.
Yes.
And Minimum Wages Act also, that is there. And your lordship, then the para comes the internal page 5, your lordship. The appellant further argued that there is no provision under the EPF and MP Act for rejection of books of account maintained by the appellant in normal course of business and not to place reliance on these books of account for the purpose of assessment under section 7A. Thus, maintenance of books of accounts for an indefinite period cannot be visualized. Moreover, if there is any violation of the Payment of Wages Act and Minimum Wages Act, there are specific authorities under these statutes to take notice and proceed against the defaulter. Respondent Commissioner's suggestion that the presiding officer EPF tribunal may ask the appellant to furnish details of workers holds no ground, as it is apparent from the records of the impugned order that whatever the facts and figures were available with the appellant has been brought to the notice of the learned authority under section 7A and 7B of the Act. In Food Corporation of India versus Provident Fund Commission and others 1990 Supreme Court, the Honorable Supreme Court has held that it is the Commissioner's obligation to collect evidence, to exercise all his powers and to materialize both before coming to proper conclusion. In this case, FCI was facing difficulties in collecting the lists of all workers engaged in depots scattered in different places. Though the employer and the contractors both were liable to maintain registers of the workers employed, but the question is whether the commissioner, who has the statutory authority, has exercised powers vested in him to collect relevant evidence public records in determining the amount payable under this Act. It would be failure to exercise jurisdiction, particularly when a party to the proceedings requests for summoning the evidence for a particular person. Again, S.K. Nasiruddin Biri Merchant's case, Your Lordship, the Lordship finds the SLIPs are dismissed. It is open for the petitioner to collect the names of the BD workers who work for them through their contractors and furnish the name of all workers to the Provident Fund Commissioner. The Commissioner thereafter will verify those names and calculate the liability of the petitioner on the basis of such verification. If any excess amount is found due from the employer petitioner, the Provident Commissioner will recover such amount from the petitioner. On the other hand, if any amount is found to be due for the petitioner, the Provident Fund Commissioner will refund the same. The petitioner so furnishes the names of the workers as above within 6 months from today. Similar principle of law has been followed and laid down in Bajrang Padia versus State of Orissa 75 LIC and National Thermal Power Corporation versus RPFC and another 98 CLR. Settled principle of law by the Honorable Supreme Court, Orissa High Court and Calcutta High Court as aforesaid support the case of the appellant. Even if the reply filed by the respondent has not been addressed to the main grounds raised by the appellant as discussed as above. Appellant has also contended he has already deposited on his own amount in respect of contractors, employees of home workers. And if the respondent PF Commissioner was of the view that if any other amount was to be assessed, then the respondent was duty bound to identify additional beneficiaries, their whereabouts, and the quantum of benefits. This means that there is substance in the arguments of the appellant that the whole procedure adopted by the APF Commissioner is contrary to the scheme of the Social Security legislation, and it defeats the very purpose for which the Act and the schemes have been framed. The respondent in his reply has made a vague denial on the ground of appeal that the respondent has failed to furnish convincing reasons to justify the facts and factual position and has not been able to successfully demolish the ground of appeal. In view of the above and after considering the argument, pleading and documents of both parties, the clear position that has emerged is that the RPF Commissioner ought to have exercised the statutory power to call the contractors, collect the details of the workers, their identities, wages paid, and thereafter, on the basis of relevant fact and evidence, he should have assessed the dues. He has failed to exercise his jurisdiction, and the impugned order passed is not based on relevant material, facts, and evidence. After considering all the facts and circumstances, I am of the considered view that the impugned order is not sustainable under the law. Therefore, the appeal is allowed, and the impugned order, as mentioned in the appeal, determining the amount of dues against the appellant is set aside and quashed with immediate effect. In the result, amount deposited by the appellant with respondent commissioner be refunded within 15 days, along with interest at the rate of 12% within 15 days from receipt of this. This is most important, Your Lordship. Amount deposited with the appellate commissioner. This relates to the statutory amount, Your Lordship, on which the appeal was entertained and admitted, Your Lordship.
This is not the contribution part.
Why not?
This is not the contribution.
Contribution, Your Lordship. This is not the contribution. Yeah. Yeah.
That's all. What is the learned single justice order?
Because there is another part, Your Lordship, because which I am representing. That order is at the enclosure 4, Your Lordship. Almost a similar order, Your Lordship. But there are certain details because I had produced evidence in that case, Your Lordship.
In respect of the number of the workers and their identity.
Yes. It remains the same, Your Lordship.
issue remains the same, Your Lordship. Only the period is different, Your Lordship. This period is from 12/97 to 3/2002, subsequent period.
Mr. Mishra, that I would request you only to give a sheet of paper, not typed also. There, I find there are 3 periods actually.
Yes, Your Lordship. See, one is overlapping.
One is overlapping.
Yes.
So just identify this period relating to the cases.
Okay.
That will help us a lot.
Yes, Your Lordship. I'll give it to Your Lordship. I'll give it to Your Lordship. Your Lordship, here also, the order is there, Your Lordship finds. The first 2 pages, just a brief narrative, Your Lordship. And third page is, I come to the conclusion that whatever the table is given, Your Lordship. How he has arrived at this thing and for whom, that is completely absent in the order, Your Lordship, in the 7A order. And in these cases, these 10 writ petitioners or 10 establishments, there has been no 7B, Your Lordship. 7B was not done.
This 10 establishment.
Enclosure 4, Your Lordship.
That is
Yes.
So the 10 writ petitions filed by them.
Yes. That's fine by us, Your Lordship. The 10 establishments. And there are 19 appeals, Your Lordship, here. And Your Lordship, the order is enclosure 5, Your Lordship. Almost similar to what Your Lordship have passed in enclosure 3, Your Lordship. And the date is different, Your Lordship. Yes, now completely. And Your Lordship, may now Your Lordship take to judgment, Your Lordship. Your Lordship, if Your Lordship permits that it can be taken up on the next Thursday, Your Lordship, so that I will come up with these figures, Your Lordship.
No, next Thursday is working day.
Next.
And I request you, this you got the note?
Yes, I got it. Yes, I got it.
Let's give him a note, Your Lordship, copy to me.
And he has exhaustively covered these areas, including the 3 Supreme Court decisions.
Yes.
That was used in the enclosure. This is clearly laid down the law. Regarding the liability, who will identify the employees and strength of the employees, and regarding the payment and non-payment of the due share, employee's share, or the
employer's share,
worker's share, and others is that whose responsibility is to find out the names. Definitely, if the notice is given, it becomes the responsibility of the employer to furnish the records, whatever he has maintained.
Yes.
If you do not depend on that records, it becomes your burden to find out the person.
Exactly.
And perhaps the approach you have taken, we have not elaborately scrutinized as yet, that even against the number of BTs and you find the per capita employer and fix the liability, cannot be, it is a very scientific and legal method.
Correct.
So we'll ask you only a single question on the next date, that how you have determined and identified the individual member of the provident fund. Yes. If you cannot answer, this will be very unfortunate, because we have to interfere in the entire order of the learned civil judge.
Yes.
Yes, in the batch of my matters, they are all identical, what Mr. Mishra argued for similar. Just to facilitate, because I have given a date check and comparison of judgments, and all the judgments your Lordship will find speaks in one singular thing.
Yes, that was also
I have already
said that. Yes,
contribution is what you employ. Yes, identify the employer. Basic thing is only the subject matter is identified. How can the collect?
Yes. And for whom it will be deposited?
Yes.
You have given the one collection only.
No, I have given 2 copies, two compilations. One.
No, 2 copies is all right, but one compilation. No,
One compilation of judgment.
Comparison judgments.
Other notes. Other one is
Yes. And one date check also, covering all the relevant dates.
listed again on 22nd September 2023 as part of the 12.
21st, Your Lordship, you see.
21st?
21st.
Yes, 21st. That's part of it. So we have heard extensively and counsel for the petitioners. But on request of the land council of the petitioners, we are adjourning the matter on condition that on the next day, they will be only provided 10 minutes to conclude the.
We agree with us. We agree with us.
And another 15 minutes will be granted to the land council appearing for the Provident Fund Commission. This represented by you are Mr. S.K. Patnaik.
No, Mr. Umakant Mishra.
Mishra or Umakant Mishra?
Umakanta Mishra.
But
anyway, it is Umakanta Das is there.
No. In the causally it is written as or somewhere it is Das.
It's good that without affidavit,
Council for the RPF Commissioner as Mr. Umakant Mishra, not nowhere as Mr. Umakant Das.
yes.
Located as part of the.
Yes.
Continuation already.
Give a correct name to the authority so that they will send the proportional fee in the correct.
Your Lord, sir.
Item number 11.
My lord, petitioner is a Baleswar Central Cooperative Bank challenged the annexure 1 series, part by this Honorable Single. My lord, directing to operate the locker to the opposite party number 1, respondent number 1. My lord, husband of the respondent number 1, so assistant secretary and in charge secretary for period of 26/11/2018 to 31/3/2021. He has misappropriated 6 crores 36 lakhs 6,28,000. My lord.
Just a minute, Mr. Sahu.
Yes. Yes. Yes.
My lord, Annexure 3, page 27, issued by the Assistant Register Cooperative Society, Baleswar Circle, not to operate the locker. Because he is a husband of the respondent number 1, who misappropriated 6 crores, and the respondent number 1 has also not given amount of 31 lakhs 61,921, which he has abandoned. My lord, in the locker, the ARCH government officer issued a letter to not to operate the locker. That order, letter number 890, dated 24/7/2020, was challenged before the Honorable Single Judge. Single Bench directed to not to operate. My response is, this is a public money, my lord, and also dispute against the respondent number 1 pending before the Register Cooperative Society Odisha under section 68 of OCS Act, under Odisha Cooperative Society Act. Same is pending, my lord. And the respondent number 1 is not appearing in spite of issuing twice notice to the dispute case. The Pranapana Service Cooperative Society, the Concerned Society, the respondent. What is the dispute before the tribunal? The tribunal, Registered Cooperative Society. 6 crores from the respondent number 1, my lord. Because her husband misappropriated more than 6 lakhs.
That fact was brought to the notice of the single judge.
May I interpret it? No, my lord.
That failing dispute case, that was not brought to the notice.
That is not the subject matter of the impugned order also. The regime assigned in the impugned order is something different, and whatever my knowledge say submitting, that is totally out of the context of the litigation. 27 of the interpreted Annexure 3,
Not 26.
27, Annexure 3, 20, letter number
Dated 24/2022.
16, which finding impugned order dated 24 July 2022 is set aside
the petitioner is liberty to operate the locker with regard to the contents therein. Mr. Sahul, honored advocate, also appeared on behalf of applicant in high number such and such made by the Pona primary agricultural cooperative society for intervening in the hearing. Mr. Sahu was present throughout the hearing, representing his client. My lord, after direction issued by this honorable court, locker was open, only 17 lakhs something bill was found. My lord.
What is the value assessment and you give the
total 17 lakhs.
That is 52,180. It is the assessment accredited value.
Assessment I filed along with my counter affidavit at page number. In my counter affidavit, pursuant to the direction of this court, the value assessed the value at page 56 of my counter affidavit. Affidavit filed by 4. That is the valuation is 17 lakhs 52,180. Yes. Only.
That is what that has been reflected in the order dated 12th October.
What may I submit, Millet? Initially, the Ashton Registered Cooperative Society on 27/2020 passed an order preventing it to operate the locker. That contents of the order I am reading, Millet. With page 27 annex.
There is no dispute. It is the
ground for prevention of the locker is that the Ashton Registered Cooperative Society suspect that any document pertains to the vigilance case may kept in the locker. That is the regime for prevention.
Yes.
That a vigilance inquiry is going
that is the order number.
Order number in page 27 annex 3. That was the important order
24/7.
24/7, yes. The branch to address to the branch manager, Bahanagar branch, Baleswar Central Cooperative Bank, not allow to operate the locker kept in your bank in the name of Sujata Das, wife and Soja, ex-in-charge secretary of compliance. Yes. With reference to the caption subject, I am to say that you are well aware about the fact of Pampana SCS. A huge amount of misappropriation has been committed in Pampana SCS by Pradeep Kumar Das, ex-in-charge secretary of Pampana SCS. It is learned that a locker facility has been available by Sujata Das, wife of Pradeep Kumar Das. A vigilance inquiry is going on in the matter of misappropriation. There is apprehension of counterfeited society document and assets relating to the misappropriation may be kept in the locker of Sujata Das. So you are requested not to allow anybody to operate the locker maintained in the name of Sujata Das, wife of Pradeep Kumar Das, till the finalization of the vigilance inquiry. On the basis of this order, I have prevented from operating the locker. I have filed the petition including the vigilance department as party, state as a party, and the vigilance department submitted the counter affidavit that I am not accused in the criminal case. There is no nexus between myself and the contents of the locker. Thereafter, the court, this Honorable Single Judge directed for making an inventory whether there is a counsel open number 4. Open number 4. Where is the vigilance department? And there submission has
not an accused in that case.
Not accused in that case. On 21st March 2022, the order of the Honorable Single Judge as per 27. Page 27 in my counter affidavit. On that day, my honored senior at para 5 submitted that
Just a minute.
he has the account is operated.
Wait, Mr.
Again.
Okay, if you do it by
At page 27, the
vigilance counter and that
well, that submission of the record. So I am pointing out the order that was reflected.
no counter affidavit. You want to see the counter.
So in submission, he appeared and submitted.
Look, ARCS counter is important.
Yes, I am submitting each not core. Well, kind of clients to for the moment order dated 21st March.
State vigilance or their internal vigilance?
State vigilance.
State vigilance.
State vigilance. Vigilance comes in.
So where is the counter?
He has appealed and submitted before the court.
I think recorded by the court. Where? In which order?
Dated 21st March 2022. That time was the proceeding of the honorable civil judge. I am placing page honorable civil judge, page 27 in my account of the analyst.
Mm-hmm. 27 for 2020.
27 of my counter affidavit, order dated 21 March 2022.
So come to
The paragraph when this honorable court found
there is one order of the London Civil Judge on 25th of April 2022.
Prior to that,
just I'm coming. Where he was saying that in letter by which I believe the bank was asked to not allow you to operate the locker. 27th of July 2020. That was the letter.
That has been corrected in the order. In order dated 25 April, in the interim order, the order dated has been wrongly typed as 22. That has been corrected in 20. That is a correction order. Page 37 is the correction order. Typographical correction order. The interim order is 27, 2022.
22.
20.
20.
That has been corrected. That has to be read as 20.
But that order was quashed.
Quashed.
Okay.
The reason for quashing the order, but the attempt and exercise has been made before the signatures. That I am pointing out.
That order dated 21/3, 2022.
2022. In that order,
that is annexed to your counter
affidavit 27. In the one the signatures found, the IRCS made a particular reason that there is a suspect of taking up the document pertains to misappropriation in the locker. Therefore, till finalization of the vigilance.
Where is which paragraph you are referring?
Paragraph 1, the order has been quoted, Paragraph 1, with reference to the caption subject, I am to say that you are well aware about the fact that a huge amount of misappropriation has been committed in Pompala SCS by Pradeep Kumar Das, ex-in-charge secretary of Pompala SCS. It is learned that a locker facility has been availing by Sujata Das, wife of Pradeep Kumar Das. A vigilance inquiry is going on in the matter of misappropriation. There is apprehension of counterfeited society document and assets relating to the misappropriation may be kept in the locker of Sujata Das. So you are requested not to allow anybody.
Paragraph 2 of that counter.
Paragraph 2 of them. Standing appear in the opposite part number 3 vigilance and submitted no instruction have been issued by each client regarding the locker. He submits for that he has instructed that neither the petitioner nor her husband was named as accused. Thereafter, contention of Mr. Sahu that Mr. Sahu, when an advocate appears on behalf of the opposite partner or bank, submits its bank's money that has been misappropriated. Husband of the petitioner who was in charge of secretary of the Pompala Service Corporate Society had misappropriated the funds. Said person died. There should not be interference. On query from Mr. Satpathy submitted, his client is willing to submit inventory of contents of the locker. It is the bank who is interested in contents of the locker. To that end, court can appoint special officer for purpose conducting the inventory contents in the locker. Para 5 is the important one. At this stage, Mr. Sahu submits petitioner be allowed to operate locker. Before the signature, they also disclose the petitioner will be permitted to. On query from Mr. Panda, submits through on behalf of the vigilance department, submission have been made regarding the petitioner and her husband not being accused, but his client relies on past affair dated 31st December 2020, wherein there is a clear allegation against the deceased husband of the petitioner, but recommendation of initiating criminal case against the other persons since the petitioner died earlier prior to 23rd July 2020. Ashton Restored Cooperative Society Baleshwar Circle, along with the petitioner, approached the opposite partner 4 on 24th March 2022 at 3 p.m. On that time, branch manager along with the petitioner will proceed and open the locker. An inventory is to be made of the contents to be signed by the Ashton Restored branch manager and petitioner who may be accompanied by one person, either relative or legal advisor. The inventory report is to be filed on urgent date through London advocate for the state on corruption. Thereafter, the inventory has been made. After inventory, the authority found only gold ornaments of a widow, some rings and bangles found in the locker. Thereafter, on 6/4/2022, the counter affidavit filed by the authority and opportunity has been given to the bank to show the proximity relationship with that gold ornament with the bank's property. That has been reflected in the para 2 million. Page number 32, madam. Mr. Ponda advocate.
6-4, you are referring to.
6-4, madam. Mr. Para 2 minute. Mr. Satpathy advocate para 1 appears on behalf of the petitioner submit the inventory pursuant to the direction in order to 21st March 2022 was made and report filed. He points out from the impugnated document so the allegation was counterfeited society's document and assets relating to misappropriations may be kept in his client's locker. No document was found. That is the inventory list found. His client's personal gold ornaments were found and recorded in inventory. Mr. Ponda advocate, additional government advocate, appears on behalf of the Assistant Registered Corporate Society. His clients are his liberty to file additional affidavit regarding the assets inventory. In event his client claims any or all articles found in the locker as assets relating to the misappropriation, court will accept some substantial basis for the claim to be furnished in the affidavit. Advance copy of the affidavit must be sought on Satpathy. The affidavit will be accepted on urgent date. Mr. Ponda submits opposite party bank is required to also give inputs because his client is only the custodian. Opposite party number 2 in making ready and filing additional affidavit may require assistance and inputs from the opposite number. Opportunity has been given to the bank. Thereafter, the order has been passed on 24/2022 at page 34. The final imprisonment order before this. In that order, they have failed to produce any document to establish the proximate and direct relationship of the contents of the locker and the misappropriation or document as alleged in the notice 24/7/2020.
My lord, annexed audit report.
What they advancing even the new case, the service dispute case has not been initiated at that point of time. There is a clearly separate law, separate procedure, operation of the locker governed under the Banking Regulation Act. And the service dispute, they have a scope. If they have a right of lien or any question of pattern, there is no order pattern. Then nothing else.
Mr. Sahu, my lord, only explain my lawful authority. Yes, what is that lawful authority? Reliance says there is no case. Yes, sir. So dispute case is pending. Then there is no order restraining the operation of the locker account. Yes. So how can you insist that he should not operate?
My lord, as per the materials available in the locker, it is now open.
After open, only go it is the account of the customer.
Because you suspected some other documents may be there. There is no such document.
6 crores.
That is a separate issue. Go after these questions.
Must have some lawful authority to restrain operation of that account. Can't just do it in air.
If you also pass order directing to the authority to take legal action as
that there is an order by the Reliance authority. Yes. Council acting for this
there is no vigilance case. Not against the disease.
But audit report, as per the audit report, page 23, that amount of that is the amount against the respond number 1.
You should have moved that in that dispute. Sir, passing appropriate order.
If there is some financial liability, even if you pass through the audit report, that may not be the criminal offense in some cases.
Yes.
So first, if there is no criminal case and the persons who are responsible for investigating the matter doesn't require this kind of sealing of this locker, why the court should do that? Court should not do that, and the bank authority doesn't have any business to do that.
The money in the Central Cooperative Bank.
Yes.
Man, this primary society affiliated to the Balancing Central Bank. Balancing Bank released the money. Said money misappropriated.
It's a separate account, separate transaction procedure will be followed there.
As on date, you have made certain allegations. He has not been found guilty yet, nor convicted in a criminal proceeding.
Okay, once that happens, he is not implicated in a criminal proceeding. Not even implicated. So once you come to the conclusion that he is guilty of these allegations, and the person is already dead. Husband may be dead, but wife is a legal heir. Legal heir, the auditing report shows more than 10 lakhs. Against the legal heir, 10 lakhs.
Yes. Then go for the recovery proceeding.
My lord, deducting the 10 lakhs, 7 lakhs money may be released. My son,
We have no business to prematurely determine anything.
or a liberty may be granted to the bank, opposite party, bank, applicant bank, are responsible to recover the said amount in due legal process.
You saying that inquiry is going on and will direct you to.
That is one inquiry. To dispute case, that is a statutory dispute.
That is statutory dispute.
She is not appearing, my lord.
That court will, this dispute case will follow towards this logical end. That we are not.
Observation, ma'am.
No. You are Mr. Sahu.
My lord.
B. Sahu. Heard Mr. B. Sahu. Learned counsel appearing for the appellant Balashur Bhadrak Central Cooperative Bank Limited. We have also heard Mr.
P.K. Satpathy.
P.K. Satpathy, learned counsel appearing for the respondent number one. And Mr. Sangram Das.
Sangram Das is not there.
Okay.
The signing, additional signing comes for vigilance. Anybody for vigilance department present?
Mr. This Moduli 3, 4, and 5. 3, 4. So not superintendent of police vigilance, there is separate counsel.
In different panel.
Mr. P.K. Moduli, an additional government advocate, has appeared for the opposite parties number or respondents number 3 and 4. By means of this intercourt appeal, the order dated 24/4/2020, 22, passed in WPC number 27279 of 2021, which was later on corrected by the order dated. Correction order was passed on
25 April 2000. 25 4. 25 4 per month.
2022 in the same repetition. Was with a single judge has been challenged. By the said order dated 24/2020, the single judge has allowed the writ petition, which was filed for a single relief of allowing the petitioner to operate this bank locker in the appellate bank. In the order dated 21st March 2022, when a single judge had occasion to observe that on query from the court, Mr. Panda submits, comma, though on behalf of Vigilance Department, submission has been made regarding the petitioner and her husband not being accused, but his clients relies on the first information report dated 31/12/2022, wherein there is a clear allegation against the deceased husband of the petitioner, but a recommendation of initiating criminal case against the other persons since the petitioner died earlier on 23rd July 2020, unquote. It starts for quoting on query from. Thereafter, at the instance of the court, the subject bank locker was opened and an inventory was prepared and no documents were found in the inventory or in the locker, though the letter requesting the appellant bank what is that letter? 20th letter.
Page 27 of the writ appeal, 24/7/2020.
Oh, sorry. The count taken in the letter dated 24/7/2020 by the estimator of the cooperative societies, Balasur Circle, before whom the dispute case was pending, was that there was apprehension of counterfeited societies document and asset relating to the misappropriation may be kept in the locker of Sujata Das. Sujata Das was the wife of the deceased, against whom some allegation has found place in the FIR dated 29/12/2020, Annexure 1 to the writ petition. After the locker, this next para, was opened, no incriminating materials was found and inventory was prepared in presence of the representative of the appellant bank. So, therefore, the apprehension as expressed in the letter dated 24/7/2020 within bracket Annexure 6 to the writ petition was found to be incorrect. Moreover, the Land Council for the Vigilance Organization, within bracket, the opposite party number 3 in the writ proceeding, has clearly made a statement before the learned single judge. Neither the deceased employee nor his wife, namely Srimati Sujata Das, has been implicated in the vigilant case, which has emanated from the said FIR within bracket Annexure 1 to the writ petition. Taking into account all these facts cumulatively, the said impugned order has been passed. Stop. Mr. Sahul and counsel appearing to the appellant has strenuously argued before me that if the operation of the bank locker is not allowed to be in effect till the dispute case is by the Eastern Register of Cooperative Societies. Register or Eastern Register of Cooperative Society. Register of Cooperative Society is disposed of. And in that case, if finally any order of recovery is passed, it will be very difficult to recover the said amount from the petitioner respondent. So, but Mr. Saul and counsel has fairly admitted the position that there is no vigilance case against the writ petitioner. So, recovery is a completely a different process which doesn't involve all the time unless there is a specific criminal case against the person who is holding the bank account or the bank locker. So, we do not find any merit to interfere with, you find this in the appeal to interfere with the impugned decision of the learned single judge. Accordingly, appeal stands dismissed.
Liberty may be granted to take a legal action as per the decision.
Liberty law permit. No liberty is required. If you observe, all right, you take on the next Thursday. Huh? It permits most of them, otherwise give over the October.
Item 30. Urgency is there. The government is going to demolish the house of a landless person.
All right, we'll take over 21st.
That's it, 12 also. 12, item number 12. 14 more. My lord, your landless person. My lord. See, notice, I have arranged the notice. Tahsildar notice to that encroachment notice. Annexure 2. Page 18. Running. Page 18. Page 18.
It has taken the update.
Annexure 1, read petition with all annexure.
In the physical copy.
Read petition annex करते हैं 40 number page read petition to annexure 1 with all read petition with all annexure.
That page?
Page 18.
Just see the also observation of the learned single judge.
My lord.
In the order dated 15th July 2022.
My lord. Only point of limitation rejected my read petition. It was delayed about 21 years. Filing of read. A revisional court dismissed the revision petition.
Notice has been issued on the limitation application?
No, my lord. Notice has not been issued.
You are Mr. BP Mohanty.
My lord.
You notice and keep the status quo till the unreasonable date, huh? Heard Mr. BP Mohanty, learned counsel, appearing for the applicant. This order is in I number 1604/2023. Huh? This is an application for condonation of delay of 2 months and 15 days. According to the stamp report, the delay is of 221 days in filing the intercourt appeal from the order dated 15/7/2022 passed by the single judge in IA number 9054/2022 and the consequential order of the same day in WPC number 16857/2022. Stop. Issue notice as to why the aforementioned delay shall not be condoned or any other orders. Order or orders shall not be passed as deemed fit in the circumstances of the case. Notice is made returnable on 19th October 2023. Can you accept that the delay can be condoned?
Otherwise, let notice go, my lord.
That is should be because
Let notice not go.
more delay, 200 is something odd. All right, noticed, all right. Since MS Patnaik, additional government advocate, appears and waives notice for the opposite parties, no formal notice is called for. Then the date should be shortened, 5th of October. 15 days is sufficient for filing the reply. Yes. In the meanwhile, the opposite parties, if they are inclined to file the objection against the prayer of contention, they may file their objection. In the next case, there is no IA for this stay.
My lord, IA is there.
22 years delay, my lord. So that-
1605, all right. We have issued notice in the condonation application. Stop. Meanwhile, the status quo in respect of the subject property shall be maintained by the parties.
That's it. Item number
My lord, 22 years delay, only that. Almost 22 years.
Raise the objection, 5th of October. Present date.
That's it. Item number 12. Lordship, kindly keep this matter on 21st. My learned for that.
All right.
Item number 13 may be taken up tomorrow. Today I mentioned, but it cannot be taken up. I do not want. Item 13 is.
Item 12,
Item
13 meeting order to continue. But item 13 is about to file the counter order. Let some.
Tomorrow it may be listed. Some kind of vision of they have taken time only.
I have written to the Home Department, but Home Department wrote a letter that this matter doesn't pertain to their department. It is.
Already sent letters to all concerned collectors. We have received. They have received also response to. Madam, 1 minute.
Let it come tomorrow. We have already 1:30.
Yes, ma'am.
Mr. Madam, tomorrow. There is no time for you to hear the matters. Extensive. I'm just quickly the name of the council.
Orders item number 1. WPC number 16300 of 2019.
This matter is coming up to 2019 for the past time, Mr. Ben. give one this term. There's none appears for the petitioner. The matter will be listed on Thursday next. It is made absolutely clear if on that day no representation is made available, will be pursued to pass an order for non-prosecution. Mr. Rona Bahiral and additional standing counsel appears for the opposite parties.
Item number 2.
Madam, I filed the written matter on the following matter. This copy of this.
They file the review, let them serve a copy.
Yes, madam. A copy with me, madam. But this petitioner, so the petitioner's husband was a junior trackman madam. He was a psychiatric patient. He was for months together madam, moving here and there, and he was undergoing treatment before the psychiatric madam, acting professor of medical college Bulla madam, and he was unable to file leave application to the additional division in railway madam, under which he was working with the junior trackman madam. And due to the long absence, my lord, he has been dismissed from service. Yes. Yes.
How can you claim rehabilitation?
Yes, madam, I have given an appeal, madam. You will not kindly grant to Minister 5, madam, or Minister 5. This disciplinary authority has issued a letter to me, madam. That is 21/1/2013. By closing because the junior trackman was died in the period of appeal, madam, within 45 days. Section Rule 20 of the Railway Government Servant Disciplinary Rules, madam. The filing appeal to the appellate authority will be 45 days. If the trackman died within.
What happened to the appeal?
Yes, the appeal pending, madam. Your sure can see annexure 6, running page 19, madam. The wife, the additional division of the disciplinary authority has issued a letter, madam, on 21/1/2013 to Sri Subhash Nilwa, the present petitioner, to close the appeal and close the DP and submit it to the appellate authority for consideration. And directed this petitioner to approach. Thereby, the mercy appeal for the removal of service is petitioner has filed an appeal. I therefore request your honor, kind honor, to withhold hands to consider my appeal on humanitarian ground to withdrawal of removal of service. And to that effect, I rely on the decisions of the Honorable Supreme Court, madam. Very Honorable Supreme Court, madam. Yes, yes. I have reported appeal, madam.
If the removal of substance for this, one of them that may be disproportionate.
Yes, yes, I did, madam.
But in your case, how can you maintain an application?
Yes, madam.
Unless that, having pursued that appeal.
Madam, I have in my writ application, I mentioned that since the appellate authority are not disposing my appeal, I have come for a direction, madam, to the tribunal. Tribunal, without considering, rejected my. Therefore, I come to this honorable madam. I give tribunal, madam.
You just come to the counter affidavit filed by the opposite parties.
Yes, sir.
Para 6, the last few lines.
Counter, yes.
Last few lines, the delinquent employee did not challenge the said punishment.
Yes,
and in the meantime, he died. And on his death, the case was closed on 21st of January.
That is not true, madam. I will make regional affidavit. I will counter this matter.
Yeah, whether someone has filed the appeal after his death.
His wife
filed it.
Yes, his wife has filed. The trackman was died within his limitation matter, within the appeal period matter. And the disciplinary authority.
No, that should be appeal must be the departmental appeal.
Yes, madam. I have report department.
Why not be stated come to rejoinder?
Madam. Madam. I have mentioned, madam.
Where is the rejoinder stated about the departmental appeal? I am not finding it. Maybe
it is not departmental appeal. The applicant has filed the appeal, madam.
the applicant, the wife of the deceased employee has preferred appeal matter.
No, there can be two situations. Before his death, he may have filed the appeal.
He has not filed the.
Right, he has not filed.
Because he died within the limitation matter, within the period of limitation.
No, I understand. I'm not questioning whether the limitation of the condonation will be, whether the wife has filed such appeal.
Yes, that is annexure. I have in my original writ application, I have annexed matter, annexure 6. Matter.
This is a mercy petition.
No, you also kindly have a prayer person. I therefore request you to your kind and work to with cold hand to consider my appeal. In shape of appeal he has given matter. It's much in shape of appeal.
It is not appeal, let me say. Appeal must be under Rule 23.
But he is an uneducated person. He has
not an educated. She's writing in English and
no, somebody will
no, this appeal is a mercy petition.
It is the only mercy petition.
Mercy petition. The removal can be changed or not. Not questioning the findings.
That's our
Planet Council. Appeal must be on some ground. The findings are bad.
Sorry, madam, your authority will kindly have a grant to the second paragraph, madam. That she was a PhD patient and was undergoing under treatment of Dr. Mihiranjan Nayak, Assistant Professor, PhD, BSS Medical Hospital, Bulla Sambalpur, from 1/2009 to 6/2012. That is the reason for which he did not attend the duty and turn up to the inquiry officer. This is the paying authority of mentioned, madam.
And this person was when leaving, he did not take all the grounds. Before the disciplinary proceeding. The delinquent officer did not take all these grounds.
Before the discipline.
He was mentally not sound. I annexed the medical certificate, the prescription, etc. I annexed 2 CG.
Wherever you say in your appeal memo, as you say,
sir,
that the removal of your ban.
If not,
order of removal is bad. You have accepted the removal order and prayed for a mercy.
Because no notice was served on me, my lord.
That's a different thing, sir.
Sir.
That is a different thing. That is, order of removal has already been passed. Now you say that.
Just a minute.
Sir. Your submission is that after death of your husband, you filed an appeal. But the appeal petition does not show that you have sought for passing of that your removal order. Rather, you accepted that removal order and prayed for a mercy only.
No, we not admitted here that after death of my husband, I informed regarding the death to learn service benefit will not be provided to his family members because he was removed from railway service on 10/5 for a long unauthorized absent period, December 2008. So long, not attending inquiry on the 5th date, but before the appeal period, 45 days, extra is mentioned, madam.
It's a very difficult. Learned Council, go to the Rule 23 of the CCSSA rules 1965, which is applicable in your case. How the appeal has to be preferred. And Rule 27 says that what will be the format of the appeal.
Post marriage is not given the format of the appeal, but
no, but you have not filed. You yourself has preferred to file a mercy petition. Mercy petition only filed. Then when you are accepting it, you are only seeking the mercy on the consequence of that order.
But when the checkman was died within the period of appeal matter, the disciplinary.
You had right to appeal. We are not questioning that.
Yes, ma'am.
The reading of the entire, you have styled the petition as a mercy petition. Then we are reading also your prayer. In the prayer, we will be starving another thing. There is no challenge against any finding that passed by the disciplinary authority.
But madam, this letter of the disciplinary.
We have all sympathy for you, but you are talking about law.
Yes, sir. Your also is correct, ma'am. You also kindly have a glance to answer 3 matter. This removal order. For all along matter, this DP was started behind my back matter. I was not because I was not in sound mind. No notice was served on me. And SO3 also.
What was your prayer before the
to direct
to direct the authority.
Rehabilitation appointment.
No, madam, to direct, I will permitted with my application to direct the authority, my lord. Not my lord. This is the application I have kept in here. I have prior before the tribunal, my lord. No opportunity was given to me to let Honorable for hearing of the DP before the termination of some service or ADM Radaful disciplinary authority. Such disciplinary authorities violated the particulars of natural justice. This is a challenge, and hence I applied for remand to directly to consider my petition. The assistant division engineer Radaful is also initiated senior division.
Sir, your only remarks before the tribunal was for a compassionate appointment.
No, under such circumstances, this honorable tribunal may direct the opposite party to dispose of the representation of the applicant. This was a fair matter.
Please, you don't make some submission. Come to the prayer. Come to the first line of your issued order passed by the tribunal.
The tribunal has directly said that I have not preferred appeal and I dismiss my application. Because I have not prayed like that, madam. My prayer was to
If you are in the mind not to understand the code, then we cannot help.
One thing, madam, you will kindly have a grant to the order of this honorable court, madam. That is.
Have you annexed a copy of the original petition, original application?
Yes, I have filed, madam. The original certificate copy I have filed, madam.
No, not a certificate copy. Copy of the original application. OA.
Yes, madam.
Where is that?
Where is that going?
In which annex way?
What is the annex application?
Madam?
What is the annex way? Original application. Original application has been annexed to your writ application.
Original application I am not annexed, madam.
What was your prayer? Read the prayer in your original application.
Original application?
Yes.
Yes. Tell me, madam.
You are making reference to the original application.
Yes,
These are my grounds. You have not annexed that application. Would you kindly read the order passed by the Central Administrative Tribunal? It says 9 of your writ petition.
Please read the order at page 9.
Page 9, madam.
Yes.
No, original application's final order.
Yes, read application page 9.
Page 9. It's 6, 7. There are 7 pages, madam. 9 pages not there.
But in our record it is there. In our record it is there. In your record it is not there.
Madam, prayer portion.
Not prayer portion. Final order dated 24th March 2014.
Yes, madam. That is there.
Yes. Read that.
Yes,
is the final order.
The OA has been filed by one Srimati Subhasini Lua, stating to be the wife of the Ranant Lua, alleging inaction of the party of railway respondent in the matter providing her son an employment in compulsory ground and Mr. A.K. Das, and counsel for the appellant, and Mr. P. Rathod, and sending counsel for the railway, on whom copy has, this OA has been served for the respondent by taking through the readings and the materials placed in the court of thereof. Mr. Das submitted that carelessness of the respondent department in the matter of providing employment assistance on a compulsory ground being last. The applicant is entitled to the relief claims in this way. On the other hand, the placing reliance on the order at 10/2012 and Mr. 3 to the OA. Mr. Rathod submitted that since there is no provision for providing employment to the
So if you go on reading the entire order, you have no difficulty. But you have got what was the original application was all about.
Or yes, the operative portion.
Not operative portion. From the beginning, when they are referring to the pleadings of that original application, it says the application was for the compassionate appointment of her son. And you are just telling that application was filed for challenging the final order passed in the disciplinary proceeding.
But
Mr. Dash.
Yes, madam.
You come with a better case because we have other important matters to do.
Sure.
Okay.
Right.
Mr. A.K. Das and counsel appearing for the review petition. The review petition has been filed. Questioning the order dated 12/12/2019, passed by a division bench constituted of one of us. K.R. Mohapatra Jail, close the bracket. In WPC number 7822 of 2019. By the said order,
Madam, your lordship kindly remember the order dated 24/4/2014 of this honorable court. This honorable court directed the railway department to produce the DP file along with the impact of
which is the order?
24/4/2014, madam. This is the order, madam. I am reading the second paragraph. And counsel for the railway department is also directed to obtain the records of the departmental proceedings.
It has already been annexed in the review person page 10.
Explain the impact of Annexure 5 dated 21/1/2020 by one affidavit. This has not been complied by the railway department, madam.
All of that is purpose we do not know. Maybe some ascertaining for certain facts. It is review petition, learned counsel. You know our boundaries also. Said order, what you like? By the said order, the said division bench observed internally as follows: quote, the tribunal, while considering the compassionate appointment on the ground of death of the husband of the petitioner, has considered that the husband of the petitioner was removed from his service. However, an endeavor is made by the learned counsel for the petitioner that an application was moved for modification of the order of unauthorized absence as at Annexure 5, which came to be disposed of on 21/1/2013. Again, she has approached on 11/4/2013. However, the fact remains the removal of the late husband of the petitioner from service has not been challenged and is set aside by the competent authority or court. Saptara. In view of the matter, we are in complete agreement that the view taken by the learned tribunal, no case is made out for interference. According to the writ petition is dismissed sense merit, unquote. So in this regard, we would like to refer to the final order passed by the Central Administrative Tribunal on 24/3/2014. Having recorded the stated fact in the original application and the submissions made by the respective counsel for the parties, it had been observed that in view of the order dated 10/5/2012, in which the husband of the applicant was removed from service in a major disciplinary proceeding, the applicant is not entitled to relief claimed in this way, hence way stands dismissed at this admission stage. There should be no address to cost and up to admission stage. Stop. By means of this review petition, the petitioner has taken several grounds, including that the order dated 24/3/2014 as passed by the Central Administrative Tribunal in OA number 927 of 2013 as reproduced before is based on deliberate, willful and misleading facts and without going through the relevant documents filed by the petitioner. So, it has been also stated that this honorable court directed the opposite party to explain the impact of Annex 5 by way of an affidavit. This order has not been compiled till the day of filing the review petition. So, on 12/12/2019, when the final order was passed, according to the petitioner, this court also did not take into consideration its own order of calling the records of the disciplinary proceeding. So, Mr. Das, when the counsel appearing for the review petition, has submitted that as per Rule 17 of the Railway Service Discipline and Appeal Rules, appeal is to be preferred within 45 days after the final order is passed. Within the limitation period of appeal, the husband of the writ petitioner passed away. Mr. Das, when the counsel has continuously made his submissions to believers, well, the mercy petition that has been filed in the writ petition being 7/8/22 of 2014 and if you switch to the writ petition, is the said appeal, and the said appeal was never disposed of in accordance with law. We have taken the pain to go through the entire mercy petition and is constrained to observe that not a single word has been invested to question the final order of the disciplinary authority, whereby the petitioner was removed from the service, and that order was, the delinquent officer was relieved from the service. Whereas, so in the mercy petition, some grounds have been taken that the petitioner, the delinquent officer was husband of the writ petitioner, was suffering from some mental illness, but no paper has been shown before us that that fact was brought to the notice of the inquiry officer who was conducting the inquiry for and on behalf of the disciplinary authority. Stop. In such circumstances, we cannot interpret this petition as an appeal. Rather, it is a mercy petition, simpliciter, and for providing compassionate appointment. Stop. And that was also the pleadings, as we gathered from the final order of the Central Administrative Tribunal, that for death of the delinquent officer, his son shall be provided with a compassionate appointment. But since the husband of the petitioner, the original applicant, was removed from the service, the scheme cannot be attracted in such death. And therefore, the Central Administrative Tribunal is in the stage of admission dismissed that original application. Challenging that order, the application seeking judicial review in the form of a writ petition was filed, and a division bench of this court, as stated above, has dismissed that writ petition. We have considered the grounds taken by the review petitioners. Stop. Within the parameters for entertaining the review petition, the grounds is cited in the review petition do not make out a case that there is error on the face of the record, and that the disclosures of subsequent action can impact the order of the division bench. Moreover, here the considered view, this review petition has been filed on some perceived facts which are not borne in the record. Accordingly, the review petition stands dismissed. However, in these circumstances, we will not impose any cost. Mr. P.K. Paril and Deputy Solicitor General has appeared for the.
Along with Mr. Maharana.
Mr. M. Maharana for the opposite parties. Sorry, Mr. Das, come with a better case next time. When you are filing a review petition, you must know.
Item number 3.
I beg pardon, my lord. I am appearing through VC. I am not well, my lord.
All right, is the next day we will list the matter if you are not well.
No, my lord. It is listed only for the restoration of the main petition, my lord. The main writ petition.
Who is appearing for this? I find the Kendriya Vidyalaya is one of the parties.
I am for the Kendriya.
For all the other persons also?
No, I am for the Kendriya Vidyalaya only.
Okay.
The main petition was dismissed for non-prosecution.
Maybe, but without notice to the opposite party, how can we decide that? Recall that.
They appeared in your writ petition
Whether he appeared in the petition.
Almost, my lord. It's a transfer brief, my lord. I have to verify the status.
The notices were served on them. Can you, can you say whether the notices were served on the other opposite parties?
My lord, in the
writ petition, whether the notice was served on the other opposite parties?
Because previously, previous council conducted previous council previously I was not conducted for the KBS. While it was the senior council, Mr. Santosh Patnaik was for the KBS. And now in CMAPL, I am appearing for the Kendra Vidyalaya Sangathan. And I have received the plan and filed. Therefore, I don't have any.
I think it has been discussed.
He has made all the parties of the West Bengal.
No, he appeared on the day one. Let's go to this writ petition records. He appeared, the Land Council takes notice on behalf of the citizens and put up the case after 6 weeks and shall obtain instruction. Do you have any objection against the restoration?
For restoration, twice opportunity your lordship has given twice. Your lordship's order 4 for 2019. Twice your lordship given the opportunity and after 1 year CM file. That's up to your lordship.
The opportunity was given by a clear order. Since there was no representation on the next date, if that is not there, appropriate order will be passed. Even then, they did not appear.
My lord, the main.
Same application. But I'm asking whether it was possible. Mr. Counsel, are you aware that your petition is barred by limitation?
Yes, my lord. I filed a limitation petition also. The reason behind of delay, my lord, the previous council who was appearing in the writ petition, his name was not in the list. Therefore, he missed the list, my lord. In the CMAPL, he has taken the averment also, my lord.
There is a delay of
around, my lord, 1.5 years.
1.5 years.
Yes, my lord. The petition was dismissed on 4th of April 2019 and the restoration petition filed on 15th.
Would you raise any objection or we can condone the delay?
That's up your lordship. That's up to your lordship.
No, you have a right to oppose. If you do not say that
the ground is taken that the name has not been reflected in the cause list. Therefore, I am living with your lordship because the ground has taken that name has not been reflected in the cause list. Therefore, it's lost. Lost sight of the. Yes. That's up to your lordship. My objection
is 3012 of 2014. You are Mr. Mohanty.
I am Hrishikesh Tripathi.
Vijay Jana. You are there in this record.
Yes, I filed my wakalat number.
Is there? Heard Mr. Vijay Jana on council appearing for the applicant. There is an application under section 5 of the Limitation Act for condoning the delay of 62 days in filing the petition for restoration of WPC number 5842 of 2009, which was dismissed for non-prosecution by the order dated 4/4/2019. Stop. Mr. General Counsel has stated that the name of the counsel of the petitioner was not reflected in the cause list, and that is the reason why there was no representation for the petitioner. When the petitioner came to know about this order for non-prosecution, he filed a petition for restoration, but in the meanwhile, the above referred delay had taken place. Stop. Mr. Rishikesh Tripathi and counsel has appeared for the opposite party number 1, and he has not raised any objection against the prayer for continuation of delay. As according to Mr. Tripathi, since the name of the learned counsel was not reflected in the cause list, this court may pass the appropriate order. So on scrutiny of the records of the writ petition, he finds that no notice was issued to the other opposite parties. And as such, we can waive the notice on those opposite parties, except opposite party number 1. So having regard to the reason for non-appearance, we are satisfied this is a fit case where we should condone the delay for considering the prayer for restoration. According to the delay stands condoned, this application is allowed. So in the main writ petition, same application. Heard Mr. Such and such, with the opposite party number 1. Stop it. As the writ petition being WPC number such and such was dismissed before issuing notice to the other opposite parties, we are not inclined to issue notice in this proceeding to those opposite parties. As for non-issuance of the notice, they will not suffer any prejudice. Mr. Jena, Vijay Jena, appearance of the petitioner has stated that in the cause list, the name of the counsel of the petitioner was not reflected, and that is the reason why nobody represented the petitioner, and consequently, the writ petition was dismissed. Mr. Rishikesh Tripathi and counsel appearing for the opposite party number 1, who had entered in the appearance without issuance of the notice and without issuance of the notice for the opposite party number 1. Stop. In such circumstances, we are persuaded to recall the order dated, the said order by which such and such is passed in the WPC number such and such. Stop. In the result, the writ petition being such and such is restored to its original file. Stop. In the writ petition, let the matter be listed on the next Thursday.
My lord.
Next Thursday, not issuing notice now. Next Thursday, issue notice. All right. And the writ petition be listed before the rest of bench.
My lord, the previous council is a chronic defaulter. My lord, chronic defaulter. Because my lord, he remained busy in the lower court, did not appear. Writ appeal was dismissed for default. Then same appeal was filed.
and that was dismissed for default. So for restoration, that I was going through the writ appeal, is very good grounds are there, but my lord,
I have no objections, Your Lordship.
Okay. So that is what you are discussing with him, that whether he should object or not.
I grateful to your lordship for that.
Mr. P.K. Naik, P.K. Mohanty. You are Mr. Barik.
Naik, P.K. Naik.
P.K. Naik, listed by Mr. P.K. Naik. We are counsel for the applicant. This is an application for restoring the CM application, CM appli 817 of 2019, which was dismissed for non-prosecution by the order dated 14th September
That's in
2022. Stop. The state CM appli number 817 of 2019 was filed for restoration of the same writ petition, but against the order dated
14-9.
14.9 is there. Earlier 14.9, I dictated it. 14.9 earlier. Yes. 14.9/2022. Then that will be wrong. Oh, the same order. How can it be? On the same date, writ petition was dismissed? No, something is wrong. We have to check up. Not 14.9. 14.9, the same application was dismissed.
Yes.
No, by reason not the writ petition, but the writ appeal, being WA for
11, 19.
14/11.
19.
Writ appeal orders were.
Yes.
What is the writ appeals order? Oh, by entry order. By the preemptory order dated 14/10/2019, by virtue of the preemptory order 14/10/2019, as the appropriate steps are not taken within time as stipulated by this court. Stop. Mr. A. Behral, an additional standing counsel appearing to the opposite parties, stated that. But what about the other counts? The no notice was issued on them?
OP 3, 4, 5 notices to be issued.
Why they have not received any notice?
No, this is a CMPL. That CMPL, my lord, notice had been issued.
They appeared there.
And they appeared, one party did not appear, had not appeared.
But notice was served, no? All right. Appeared for the state opposite parties. But we find from the area of parties that some private individuals were also noticed. In the same appeal number 817 of 2019. So hence, issue notice. Returnable on 19th October 2023. So, as Mr. Behral and counsel is appeared for the opposite parties number 1 and 2. And we have noticed no formal notice is called for. But the applicant shall take steps for service of notice on the remaining opposite parties, i.e. opposite parties number 3, 4 and 5, the registered post with AD within 3 working days.
Well, holidays are there, so by 21st, let's say.
3 working days. For the next item.
Item number 2.
Second copy, my lord, I am giving the second copy, please. My lord, here, my lord. The petitioner, my lord, in fact, I was not, I could not appear before your lordship when the matter was taken up, and my junior could not place the matter. And on the submission of the counsel for the government advocate, my lord, this writ petition was dismissed, disposed of with a order that since the notification is of the year 1987, it has set at rest. But the fact remains till date, the sanctuary has not yet been declared. And the procedure from section 19 to 25 has not been completed, and it is pending before the government. It has been accepted by the in the reply affidavit, reply to the rejoinder affidavit by the opposite parties that the matter is sub judice before the government. My lord, what has happened, my lord?
Before the government, any matter cannot be sub judice.
My lord, no, my lord. What I am submitting, my lord, government has given notification in the year 1984. For declaring some vast patch of land as a Balukhan Konarka Wildlife Sanctuary, my lord. Then after in the year, that notification was again modified in the year 1987 under Annexure 4, my lord. The boundary has been redefined. Thereafter, my lord, they are supposed to carry out the procedure provided under section 19 of the Wildlife Protection Act, my lord, to determine the rights of the party and to pay the compensation and to further declare the sanctuary under section 26A. Till the 26A sanctuary has not yet been declared. And the procedure under section 19 was carried out, and under section, let's see, kindly turn to annexure 5 of the writ petition, my lord. My lord, I'm placing page 31, my lord.
Yes.
With reference to the above cited letter on the subject, I am to send herewith the inquiry report along with sketch map of Balukhan Konarka Wildlife Sanctuary for your kind information and necessary action. It may not be out of place to mention here that the Honorable High Court by OJC number so and so has directed to complete the inquiry by 2/10/1992, and as per the said direction, the inquiry has been completed on 1/10/92. Where the vast patch of land has been excluded from the notification under Annexure 5, my lord, Annexure 4, my lord. So that is pending before the government. Then whether that suggested land will be, your lordship may kindly read page 46. In view of the above, last paragraph. In view of the above mentioned facts, the following lands are excluded from the boundary of the Balukhan Konarka Wildlife Sanctuary in pursuance of section 24(2)(a) of the Act, my lord. So it has to be approved by the government, and thereafter a fresh notification has to be issued defining the boundary line. Whereby the 13 mojas of villages of 13 mojas are being affected, my lord, since 1992.
Writ petition, what is your prayer?
Prayer is to dispose of this annexure 5.
Just making submission before us.
My lord, my prayer is in your writ petition, my lord. The petitioner therefore prays that this honorable court may be graciously pleased to admit the writ petition issued in calling upon the opposite parties to show cause why directions shall not be given to accept the report under Annexure 5, my lord. The report submitted by the forest settlement officer, my lord,
yes,
under section 24 of the Act, my lord.
Go on.
and de-notify the notification under annexure 3 and 4 as inoperative, and if the opposite party fails to show cause, then the said rule will be made absolute, directing the opposite party number 1 to accept the report under annexure 5 and de-notify the my lord 3.4. What has happened thereafter, my lord, after submission of this report, my lord, again some persons approached this honorable court, and this honorable court, by your lordship may kindly see an order of this honorable court, division bench of this honorable court, annexure 6, page operative portion, my lord, page 98, my lord. What has happened, my lord? Learned counsel for the petitioner as well as the learned government advocate. The grievance of the petitioner is that they are the landowners in respect of the land pertaining to the plot number so and so, measuring an area of 38 acres, 92 decimals, and 19 acres, 46 decimal in the Nimapala Tahsil in the district of Puri. And the lands were included in the notification issued under Section 18 of the Wildlife Protection Act 1972. Hearing after called the short by notification dated 23rd April 1984 and published the Odisha Gazette on 31/12/1984. The same was modified by issuing another notification dated 1st September 1987, published in the Odisha Gazette on 5th October 1987. On issuance of such notification, the collector is required to determine the existence, nature, and extent of the rights of any person in or over the land comprised within the limits of the sanctuary. Thereafter, proclamation by the collector under Section 21 of the Act. The Section 22 of the Act provides for inquiry by the collector, and Section 24 provides for acquisition of rights. Section 25 provides for acquisition of the proceedings. The Section 25A provides for the time limit for completion of the acquisition proceeding. The collector shall, as far as possible, complete the proceeding under Section 19 to 25, both inclusive, within a period of 2 years from the date of notification of declaration of sanctuary under Section 18. Having regard to the said time limit prescribed under the statutory provisions, the proceedings under Section 19 to 25 have not been completed by the state government. Therefore, the arguments of the petitioner in this case are not controverted in the counter affidavit. Having regard to the petitioner's amendment, and no material is produced that the land in question of the petitioners, which have been included in Section 18 notification of the Wildlife Protection 1972, has not been declared as sanctuary under Section 26A of the Act. That apart from that, at paragraph 7 of the counter affidavit, it is stated by the opposite parties as following. The Forest Settlement Officer Puri has suggested the government in Forest and Environment Department, Odisha, for exclusion of the lands from the sanctuary, and the proposal is pending before the government. But the process under Section 26A of the Wildlife Protection Act 1972 has not been completed. My lord, I was referring to that report, which was submitted under annexure 5, my lord. That has not yet been taken any decision by the government. So therefore, there is no final declaration, notification of the lands included in Section 18 notification, declaring them as sanctuary land. In that view of the matter, the proceedings under Section 19 to 25 are not concluded within 2 years from the date of publication of the notification. Therefore, deletion of the lands of the petitioner from the declaration notification does not arise. On the other hand, at paragraph 8 of the counter statement, it is stated by the Assistant Conservator of Forest, Puri Wildlife Division, Bhubaneswar, opposite party number 5, that after acquisition of the land, the collector issued proclamation in Odia language, so thereafter there is no proceeding initiated under Section 25 of the Act for acquiring the lands, which is mandatory. In absence of the same, the lands of the petitioners have not been included under Section 26A declaration notification of the Act. But on the other hand, the opposite party number 2 has recommended to the state government to exclude the lands of the petitioner from the declaration notification under Section 26A of the Act. This is in view of the factual position. There is no need for this court to give direction as prayed for by the petitioner, for the reasons that the acquisition process of the lands of the petitioners as notified in Section 18 notification are not completed within the
2 years as provided under section 25A of the Act. The petitioner has sought for quashing of annexure 1 and 2 dated 31/12/84 and 5/10/87. For the reasons stated supra, the question of quashing annexure 1 and 2, which are impugned in this petition, does not arise, since the proceeding under section 19 to 25 has not been completed within a period of 2 years provided under section 25A of the Act, and the declaration of the area as sanctuary land has not been made as required under section 26A of the Act. So, my lord, this honorable court has held, my lord, till that 26A has not been declared, and it is not, sanctuary has not yet been declared, and they have admitted that the report of the forest settlement officer is pending before the government for their consideration. So that in this view of the matter, this honorable court on the submission of the learned counsel for the state, that the matter already set at rest. Rejoinder. Para 5.
Area as sanctuary as mapping section 26A of the wider.
My lord, para 5 of the rejoinder.
No, rejoinder of the opposite party.
Reply rejoinder of the opposite party. Para your lordship, my lord. Yes, my lord. Thereafter, my lord, they have said that sanctuary has not yet been kindly.
No, it is by your the rejoinder.
My lord?
Yes, the rejoinder affidavit on behalf of
my lord, your lordship may kindly come to page 5.
No,
my lord.
There is 192.
You filed one rejoinder.
My lord.
You recall it?
Yes, my lord. I have filed rejoinder.
With July 2018.
Yes, my lord.
Come to para 5 of that rejoinder.
My lord. That the fact stated in para 8 is an outcome of non-application of mind by the authority. It is humbly submitted that the opposite party has claimed that the inquiry as contemplated under section 19 to 26 of the Wildlife Protection Act has already been determined, and the same is submitted to the opposite party number 5, my lord, which I am referring to.
All right, read, go with the.
So the proceeding is completed, but it is needless to say that unless and until the said report of the forest settlement officer is accepted by the government and a notification is issued with a corrected map, it cannot be said that the inquiry under section 19 to 26 is completed. And the report of the forest settlement officer has attained the finality, and the claim of the landowners are determined.
Just take a pause.
My lord.
When the report will take its finality?
After acceptance, my lord.
Who says that?
My lord,
when the report is drawn up, it is the final report.
No, my lord.
Acceptance is a different incidence.
My lord, after report, my lord.
Understand.
My lord, after
accepted or not, this is a separate fact.
My lord.
But report has reached its finality. Further report was there.
No further report is there.
And what do you mean by this? Inquiry is contemplated under section 19 to 26.
My lord,
is not complete. Again.
No, it has not yet been completed.
Why not?
My lord, no notice was given. No landowners were given notice. No, nothing has been done. No rights have been determined.
What is the report all about?
The only report is all about to exclude these patch of lands.
You mean to say it is a survey report?
Yes, my lord. It is a survey report, and on the base, and he has paid to exclude these lands from the purview of the notification under annexure 4, my lord, in the year 1987. He has not determined the rights of the parties. It has to be determined under the Land Acquisition Act. So therefore, all these things are kept open, my lord. Till that they are not able to use their lands because of the notification under annexure 4.
How the finality has come?
My lord, unfortunately, since the file has been disposed of, I have not been given a copy of the writ petition today.
Just give a photocopy of your records to him.
I'll call for the records from the office if your lordship may have it.
Already you're fixing the matter again on Thursday next.
Thursday.
List and give the date of Thursday, 21st.
My lord, next Thursday. Next Thursday. Lord, I am not available on next Thursday.
Okay, that is difficult.
On 25th or 26th.
No, this bench will sit only on Thursday. You try to adjust with your schedule if possible. Next Thursday. In the meanwhile, Mr. Behera shall reconstruct shall prepare himself to answer the grounds is raised in this review petition. We have heard Mr. Raut.
My lord.
Raut, run counsel appearing for the review petition.
Both the matters are similar. Next matter is a assignment of already single judge, my lord. But it has been unfortunately, my lord, since he could not apprise your lordships. So what has happened? That second matter was tagged up with this matter, and that was also rejected.
Disposed of.
But that is challenging the approval of the plan, my lord. Building plan.
All right. Just replicate the same order below, huh? Because you are either to allow it or you have to decide together.
My lord.
If we allow it separately, then you have to remand the matter back to the single judge.
My lord.